Good morning. Welcome back. My name is Mohammed Abduroaf. I'm a practicing advocate, and today we'll continue from what we started yesterday regarding the issue or discussing. Sorry, I'm putting the sound down. Discussing the issue of child custody, child maintenance, and divorce. Yesterday we had a bit of questions, live questions being posed. Quite a few people do not want to post questions live on Facebook because your details gets left on the Facebook page. We have decided to implement the live WhatsApp questions WhatsApp facility whereby you can ask a question live via WhatsApp. The telephone number is 021 It is a WhatsApp number. Just a matter of advising you that we will not deal with live questions afterwards. The receptionist will take over the number again, but only for the purposes of this webinar. If you want to pose a question and have it posed anonymously, you are welcome to do so via the WhatsApp number. However, it will limit our resources in dealing with questions coming live via Facebook and obviously questions coming live via the WhatsApp group. However, we'll try our best to deal with all of those questions. If you are watching this video, welcome again. It will be nice if you can maybe give us a thumbs up via Facebook or a hi or an okay, whatever the case may be. It's nice to know who are watching your live videos. If you have a question, please post it on the Advocate Mohammed Abduroaf Facebook live page. If you are not on that page, go to the redirect link www.abduroaf.co.za/live, and it should redirect you to the relevant page. I'm just trying to share this to the various platforms while I'm speaking to you. And we would like you to do the same so other people can also benefit from that. I'll just repeat myself one more time. If you would like to remain anonymous and not pose your question on our Facebook pages, where I believe it remains for other people to see, you are welcome to make use of our WhatsApp number 021 Please note, if you pose a question later on, our receptionist would not be able to entertain you, as I will not be able to follow up on that. And furthermore, you might get a automatic response from our receptionist via our WhatsApp line. So please make use of either our WhatsApp line now for the next half an hour, alternatively our Facebook Live page. Thank you for the hi on Facebook Live. Let's move on. So yesterday what we discussed was, we started off with the issue concerning a payment holiday regarding child maintenance. Please note, pay your child maintenance. It's very important that you do that. If you do not have any money to pay it, please sell your property, sell your cell phone, sell your car, and so on to pay the relevant child maintenance. If you really cannot afford it, please approach a maintenance court as soon as possible to make an application for the variation of the maintenance order. And thanks for the thumbs up on Facebook Live. It's always nice to get a thumbs up. Moving on. Yesterday we had quite a few questions regarding parenting plans and people having problems regarding child custody. It's very important to note that in all those matters, it's difficult or it's impossible for me to answer those questions in isolation. You stipulate a few paragraphs or a few lines, and for me to give the specific answer relevant to your specific case. What I try to do is I try to give a general answer whereby you can apply it to your scenario. However, the outcome of your matter, or what will ultimately happen in court, will be dependent upon thousands of words being given, thousands of paragraphs, dozens of paperwork, and so on to be presented. Therefore, when listening to my videos, is based upon years of experience in family law matters. However, the advice given on live on Facebook might not be applicable to you based upon the limited amount of information you provided. Before I go on, somebody made a comment. Hi, advocate, my ex-wife doesn't contribute equally to our child. Equally is not necessarily the law. If one parent earns much more than the other parent, then it wouldn't be fair for one parent to spend all his or her money on the child and the other parent spends 1% of his or her income. Therefore, the law does not state that you have to equally in the sense of paying exactly 50% of the child's expenditure. It is possible at any given scenario that the court would make such an order. For example, if the parents do earn exactly the same amount of income, the same amount of expenses they have, you can work out exactly what the expenses of the child is, and you can equally contribute towards a minor child. However, the law expects you to maintain according to your means. Therefore, a parent who earns no money, but he or she owns a lot of assets, cars, properties, houses, policies, investments, and so on. Although he or she is earning no money, the law would expect that specific person to contribute much more than a parent who is earning maybe a reasonable salary, but if you compare the two, one is much more wealthier than the other. The live comment goes further and says she earns more than me. Then obviously, if she earns more than you, then she must contribute more than you, depending upon the circumstances of the matter. However, with all being equal, the parent that earns more must pay more. It's this logical sense, where it does not necessarily apply on an earning capacity. If a father, for argument's sake, earns, let's say, 1,000 rand per month, but in order for him to earn 1,000 rand per month, he needs to travel to work, buy work uniform if the work doesn't sponsor it. He has to buy a lot of other things, material, as the case may be. Whereby the mother also earns 1,000 rand per month, but her work provides everything. All that she needs to do is come to work and start typing or do whatever needs to be done at work and go online. Under those circumstances, it would obviously not be fair for both parents to contribute the same, because one parent at the end of the day comes with more home than the other. So in our fictitious example, the mother obviously has more disposable income, and therefore she needs to contribute more towards a minor child. And the opposite applies as well. If the father has more disposable income at the end of the month, he needs to contribute more towards a minor child's needs. The commenter goes further and says she never has to prove what she earns. They only ask me to prove what I earn. That is obviously unfair, and I do not condone that. The maintenance courts should do a proper inquiry, and there's case law applicable to that. High Court says it all the time, that there needs to be a proper inquiry in the maintenance courts. We need to properly look at what the needs of the minor child is. We need to properly look at the income and expenditure of the mother. We need to determine, does she really require so much money based upon her income and her expenditure and so on. We need to properly look at the income and expenditure of the father. There needs to be a thorough investigation, a proper inquiry into the finances of both parties. If that is not done, then factually, the maintenance court did not do their job. That gives you proper grounds to appeal the decision. And I have been successful in appeal last in Grahamstown, whereby the maintenance officer and the maintenance magistrate did not do their jobs. They dealt with the matter in a very quick, haphazard manner. And on appeal, if you're looking through the records, there was obviously evidence and information applicable to show that the father should have contributed much more money. But the court did not consider a lot of information, and the court basically has made in his view, a fair decision, but never made a proper decision. And the courts need to make proper decisions, not necessarily fair in their eyes. Fair, for example, in their eyes, I would say, where they say, okay, the mother works, the father works, the child is 10 years old. We believe, thumb suck, a child of 10 years old should get maintenance of 1,000 rand. That is not properly done. A 5-year-old child or a 10-year-old child in one family will be different the expenditure will be different than a 5-year-old or 10-year-old child in a total different family. Therefore, it's very important. Each case needs to be looked at on its own, and you do not compare cases. That's improper, not properly to do. If you have any questions, please feel free to do it via Facebook Live, as our commenters has been doing. There's another comment. I will deal with it now. Alternatively, you can make use of our WhatsApp line, 0214243487. Add us on WhatsApp, pose a question, and we will try to answer it. Just bear in mind that after this webinar, in the next 20 minutes time, we will not answer any questions in that specific fashion. Then it becomes back to our reception line where we deal with other queries. The person who commented earlier on said the following: our child is under 2 years old and she wants 23,000 rand from me. I will not be, how can I say, jump to conclusions which many people do sometimes, and saying, oh, she wants 23,000 Rand, the child is 2 years old, automatically it's too much. I cannot answer that without any other information. I need to determine what the income of the parents are, what the specific needs of the child is, does the child have any condition, and so on. So the commenter can provide me with more information, but I would not give a conclusive answer and tell you, yes, it's fair or not. I need to determine, why does she say she requires 23,000 Rand per month? Does the child require special schooling? Whatever the case may be, certain clothing, certain medication, and so on. It is possible that a child of 2 years old can cost 23,000 Rand per month. It is possible that 23,000 Rand per month can be way too much for a child of 2 years old. If you calculate it, maybe the child is maybe on diapers, that maybe costs, I'm just using round figures here, 1,000 Rand, clothing another 1,000 Rand, food maybe 2,000 Rand, and so on, where the child, at the end of the day, cost a sum of, let's say, 10,000 Rand per month. I don't know, I'm guessing. Then there would not be a case for that. Then the maximum hours that a parent should generally pay if the child does cost 10,000 Rand per month, including accommodation, all those things, would be 5,000 Rand if the parents are earning the same amount of money. Maybe a bit more, seeing that the mother, if she is caring for the child, might incur some other expenditures, which are not necessarily so obvious. However, if the child does not cost that amount of money, clearly the parent should not maintain. You don't have a legal obligation to maintain your ex-spouse unless a court made an order, unless you were divorced, or there's any other legal basis for it. But let's say you got divorced and the divorce court made an order that you have a legal obligation to pay alimony or personal maintenance, which is used in South Africa. Under those circumstances, then you have to pay. But if not, if you divorce or you're separated from the mother or you're no longer together, you have no legal obligation to maintain the other parent. You have a legal obligation to maintain the minor child. The commenter says further, live commenter says, no special needs at all. She claims poverty. In my view, when I deal with a situation like that, I take away the 23,000 and claim. That's something, what she wants. It doesn't mean she's entitled to that. That is something which she has to prove. If she can prove it, she has to consider various aspects. She needs to consider, number one, is the actual needs of the child. That is a foundation. And you cannot move forward with a maintenance matter unless you have laid down the foundation. Because the maintenance amount which the father or the mother must pay will be based solely on how much the child cost. If the child only costs 1,000 Rand per month, you cannot be successful in a maintenance application of 2,000 Rand per month. It doesn't make logical sense. If the child costs 1,000 Rand per month to maintain, and both parents earn, let's say, 5,000 Rand per month, and the disposable income at the end of the month after they paid what they have to pay for is maybe 3,000 per month. So clearly it is an easy case. Both parents have to contribute towards the 500 Rand. But if one parent earns 10,000 Rand per month and the other parent earns 1,000 Rand per month and the child costs 1,000 Rand per month, it will obviously be unfair for one parent to use all his income or half his income if he earns 10% of what the other parent earns. The court will have to be fair, and parties will have to be fair. You need to look at the situation properly and make a decision which is just and equitable and fair for all concerned and for the minor child as well. You cannot tout the minor child's best interest. The minor child's best interest is first and foremost determined based upon what the child requires and what's reasonable under the circumstances. You cannot say a parent should use all his or her income and live on the streets, for lack of a better way of saying it, just because the child should now have a very expensive lifestyle which the parties were not accustomed to and which one parent cannot afford. That is not how it works. You have to be reasonable, you have to justify your claim, and at the end of the day, if the child requires something and it's reasonable and it's necessary under the circumstances and it's fair based upon the standard of living of the parties, what the child is accustomed to, what the parents were accustomed to before, for argument's sake, if the parents both went to university, they studied, they got degrees and so on, then obviously it makes sense for the minor child to go to university and so on. So a parent can't say, no, I don't want my child to go to university. If the parents studied up till doctoral level, they pursued certain very expensive careers, it makes logical sense. If the parents truly cannot afford it and they were living a more modest lifestyle, whereby both parents went to undergraduate level only and so on, it might be a bit unfair if the other parent cannot afford it for you to argue, no, my child must now go to the highest level of university you must now put yourself into a difficulty and so on. So you have to be fair and reasonable under the circumstances. You can't always tout the child's best interest. There is a principle behind it, and it must be fair and logical and reasonable. The person commented further, and I appreciate that. She says no personal maintenance, that is fine. Okay, we got another question. To the person who commented first, thank you very much for that. If there's anything else, you're welcome to pose it, and I'll try to deal with it as well. I see another question. I'll read it out. My ex-husband to be moved out of our matrimonial home in April. I'm reading it verbatim. I'm staying with the kids and also filed for maintenance. He is paying 10,000 rand per month. Now he has now filed for a divorce and says he wants to keep the children because his reasons is that I am mentally ill. I have suffered from his mental abuse. But I got counseling and now I'm fine. What are my chances that the children will be taken away from me? I'm just warning everybody, I cannot give a factual answer based upon a paragraph given. Generally, how I do these things is I ask you 1,000 questions, you ask me a few questions. I come to some type of an answer based upon your case only. If I want to give a proper answer, I need to listen to the other side of the story. The same with the judge. The judge will listen to both sides of the story before making a decision. But let's deal with the situation at here. So the parties are now separated. The husband moved out, it seems to me, in April. The mother is caring for the kids. He's paying 10,000 in maintenance, but he's now saying, I'm divorcing you. He's divorcing his wife. However, he's saying that he would like to have custody of the kids because she suffered from a mental abuse and so on. How do you deal with a situation like that? Yes, parents can say whatever they want to say. You know, the father can say, I want custody. The mother can say she wants custody. The end of the day is we need to determine what is best for the kids. If it is best for the kids, for them to remain the primary care of the mother, that must be the case. And if because of the mother's, if there is a condition, I'm not saying there is, or if it is best for the minor children to move and live with the father, despite the mother having been the caregiver of the minor children since their birth, then that is in the child's best interest, and obviously it must happen. It's best for the kids. Now, how do I determine, or who decides what is best for the kids? I'm a lawyer. The judge is a lawyer. Yes, he makes an ultimate decision, being neutral and, you know, being level-minded and so on. But we are lawyers. Who are the best people to determine that? Obviously, the best people to determine that would be a social worker, a psychologist, a counselor, and so on, a therapist. If truly the mother cannot care for the minor children, then the minor kids must go to someone else, maybe to the father. But we also have to look at the father. We can't just say, because the mother has an alleged mental condition and so on, automatically the father is a better caregiver. That is nonsense. I don't believe in that. It's not, for example, that if one parent has an alleged problem, automatically the other parent grows some stripes and automatically he or she is capable of caring for a child. That is not the way it works. Nobody's perfect, no family is perfect, and nobody is born with the capabilities of caring for a minor child. Yeah, you're quiet and you develop it. Therefore, I always say, if a mother has certain issues, she has certain mental challenges and so on, it does not mean the children must be taken away from her. Besides all of that, she can go for counseling, she can take medication, etc. If the children goes to the dad, and the dad never cared for the minor children and is incapable of caring for the minor children, he never done it in the past. He might not have any mental challenges or mental conditions. However, he is incapable of caring for the minor children. Then clearly the children must stay with the mom, despite all her conditions she might have. But if the father can care for the minor children better than the mother, it will ultimately be best for the minor children to be cared for by him, considering all factors. Then yes, the minor children must go with the dad, because they will be better cared for by the dad, and should they be in the mother's care, they will be neglected and so on, comparing the two parents. But if we have a situation, unfortunately, where both parents are fighting over the minor child, and there is no clear-cut, guidance or guidelines as to what would be best for the minor children, then we have to call an expert on board, and an expert will have to determine what is best for the kids. I hope that answers that. I'm trying to be general as possible. My quick advice to you is maybe go see a social worker, a psychologist, and find out from a social worker or psychologist what is their view on the matter, because they will be able to give you a better answer. I deal with on a regular basis with cases whereby the allegations are being made of mental illness, drug abuse, and so on. It doesn't cut over there, because the other parent has his own problems. And I would say somebody with a mental illness who can care for the minor child properly, despite the mental illness a person might have. It's better for him or her to care for the minor child as opposed to leaving the minor child with the other parent who never cared for the minor child, where the minor child is potentially left to be, neglected. That's where I'm going to with this. Okay, the initial commenter regarding the child maintenance said something further now. When I bring a reduction of maintenance claim, she opens a case for the NPA to investigate me. I cannot comment on that issue. If there is a case against the NPA against you, she has full right to do that. Whether or not they'll be successful, that's something else. If they are successful, that's the fact. If they're not successful, that is a factual thing. But I do not see how someone being investigated by the NPA can increase the maintenance or reduce the maintenance. I'm trying to just be general here. If someone is a criminal, and I'm not alluding to anyone here, I'm just saying NPA is obviously the National Prosecuting Authority, the authority that prosecutes someone for criminal offenses. If someone is a criminal, it does not mean you must pay less or must pay more. Your maintenance obligations is determined based upon your earnings and your net worth and your means. It's not dependent upon your status. Someone can be married culturally, religiously, and have 3-4 wives, whatever the case may be. His obligation is based upon not that, it's based upon his duty to maintain his kids according to his means, and obviously what's reasonable and understanding under the circumstances. Oh, the person early on says, thank you, advocate, you are welcome, anytime. I have another question. Hi there, my ex refuses to pay half of the kids' expenses and thinks that if we had shared custody, that he would not have to pay maintenance. He hasn't really been in their lives for the last 4 years, and they saw him last before lockdown. Goes further. There's no real relationship between them, and he is married again and with another child. I have a garnish order because of arrears. He refuses to pay and for non-attendance to court. He knows how to play the legal system, and I feel that this is just a ploy to delay things further. Will the court entertain this? And what can I say to the magistrate on the 9th when his attorney is appearing going on the record to prove that he can't pay half of the expenses, yet he earns 34,000 Rand? Thanks. So there's two issues over here where the father now wants to get joint custody over the minor children and he believes he must pay half. It's a mathematical equation. Full stop. If a parent cannot afford to pay child maintenance, then he cannot afford to pay child maintenance. If the parent must maintain the child and pay more child maintenance, clearly the parent must pay more child maintenance. It's a factual thing. I cannot answer fictitiously or hypothetically or like in a crystal ball as what will happen in the future. But all that I do know what you must do in order to get the best results is to go to the maintenance court well prepared. You need to outline to the court. These are the minor children. These are the expenditure. These are the needs. If you are the primary caregiver of the minor children, it becomes very easy. So you stipulate Monday morning, the children have breakfast. It costs so much money. This is the breakfast bill. So we bought cereal, and you need to do this exercise. We bought cereal on the Sunday afternoon for argument's sake. Cereal got used up by the next Sunday. Let's say you bought a big bag. The cereal cost 50 Rand. Or 70 Rand for lack of a better, to work out the mathematics easier. So it cost for that specific child 10 Rand a day for cereal. So you work that out. Breakfast, 10 Rand. Then you add in the milk and everything else. Then you work out lunch. You do the same principle for supper. Then you work out your monthly electricity bill, your water bill, your rental costs, and so on. You go to the court well prepared. It's very important. And it shows the court that a minor child does actually cost so much money to maintain. So that becomes undisputable. That's the foundation. Then we start looking further into your income and your expenditure, and the same with the father. He will have to do the same. So whether or not a parent earns 10,000 Rand, 50,000 Rand, 100,000 Rand, 200,000 Rand, whatever the case may be, he has a legal obligation to pay what the minor child costs, contribute towards that. His obligation is not based upon what he earns necessarily. His obligation is based upon what the minor child costs, and who proves that? The parent that cares for the minor child has to prove that. And reading in between the lines regarding that specific question, if you have 50-50 care, where the minor child remains with you 1 week, or and with other parent other week, or the end of the 30-day period, the child ultimately stays with one parent for 15 days and other parent for 15 days. It still doesn't mean that the parents must pay equally. Then we have to look at the minor child's needs. Sorry, not the minor child's needs, at the parents' income. If a parent earns more than the other parent, he or she must maintain more. But it's also possible where, should a minor child live with one parent, the expenses might be more living with that one parent. Let us say rental is a bit more. Therefore, that will have to be factored in as well. It's possible under the scenario whereby both parents are earning the same income, whereby the minor child remains with one parent for half the time and other parent for half the time during the month, but one parent could possibly have to contribute towards a minor child expenditure. Could be, for example, accommodation. That is possible. I hope that answers that to you. My advice to you is focus on the basics. That's the income of it. That's the expenditure of the minor child. The commenter earlier on said, yes, I am not a criminal. I agree with you. I'm not saying you are a criminal. What I'm saying is, if a person makes an allegations regarding something, it has nothing to do with the child maintenance. If the person is approaching the courts unnecessarily, unreasonably, you need to bring that to the court's attention. If the person does it once the first time, the person done that. If the person does it the second or third time, the court needs to know that that specific parent is being malicious and likes going to court. The person said, thank you, you are welcome anytime. Shukran. Another question, he says the following: Hi advocate, my ex-husband hasn't been paying for almost a year. There was a maintenance order in place. He paid a few weeks, then he stopped. Because of the lockdown, he says there was no work and no money. Any advice, please? I would still say I'm certain there's no work or there is no money because of the lockdown, but clearly he has a cell phone. He has a car. If he has one, he should have some machinery at home. He should have something to sell. That is no excuse. I'm certain he has a bicycle or something. I don't know. He has clothes. He has a jacket. Whatever he has, he needs to sell that and pay the child maintenance. My advice to you is to go to the maintenance court as soon as possible and lay a criminal complaint. That's it. Let the maintenance court sort this out. And some maybe additional advice further to that is, when you're applying for the complaint, when you're making the complaint, let the court know that this guy has assets that he can sell. You cannot accumulate assets in your lifetime. You earn a salary of 100 rand, you buy an asset of 50 rand, you put it somewhere in your shed, wherever the case may be, and then a year later you lose your job, all the money is up. No, the money is in the shed. Sell the assets. So that's my advice to you. Go to the maintenance court and lay a criminal complaint. And we have another comment here again. Thank you. I guess if there's no other questions on the WhatsApp line, we did not receive any questions on the WhatsApp line. I think it's a new thing. People are, hopefully in the future, will be making more use of that. We're now 29 minutes and 46 seconds into it, and the plan is to go for 1/2 an hour. Thank you very much for watching. I should be live again either tomorrow or on Thursday. If you have any questions, please type it out. Please don't go more than a nice paragraph, which I can read out, and I'll try my best to answer it. Have a lovely day, and I hope to see you soon. Thank you very much. Good afternoon and welcome back to our live Facebook webinar dealing with the topic of child custody, child maintenance and divorce. My name is Mohammed Abduroaf. I'm a practicing advocate in Cape Town. And you know, if you watched these videos in the past, we deal with live Q&As. If you have a child custody or a child maintenance or divorce query or question, you are welcome to pose it and I'll try to give a general answer to your specific question. We are streaming live on Facebook. If you're watching this video or you're part of the watch party, please feel free to say hi or give a thumbs up or to wave. It is always appreciated. If you have a question, feel free to pose it. The quickest way of doing it would be via our Facebook page, Advocate Mohammed Abduroaf. And the link is basically Facebook.com/Advocate ADV Mohammed Abduroaf/live. The link is in the screen. Or you can use a redirect link by visiting www.abduroaf.co.za/live. If you do not want to pose a question live on Facebook, we have implemented the WhatsApp line that's only applicable during this webinar. The telephone number is 021-424-3487. You add us on WhatsApp, and for this next half an hour, you may pose your specific legal question. I may read it out live, and I'll try to answer it for you as well. Please note the answers are general. It does not necessarily apply to being sound legal advice for the sole reason that you are giving the information. I'm not asking you any specific questions to verify or to appraise or to satisfy myself that I am knowledgeable of all the facts applicable to your matter. Therefore, I give general information or general advice on your specific case. Please try to be as brief as possible. Do not type out long messages. The reason for that is I cannot read it out. It becomes a bit monotonous, and many times people use shorthand typing, and it's a bit hard to read it. And I cannot screen it or proofread it before the time because it comes in live. Therefore, be very brief and short. Stipulate, I am married, I have 2 children, I have the following problem, what advice do you have? Something to that effect. As stated, we are streaming live on Facebook. You are welcome to pose your question and I will try my best to answer it. Please send us a thumbs up if you are watching it on Facebook, or give us a like. And if possible and you do not mind, please share this video. Someone else may find it useful. As always, I will quickly comment on the issue concerning child maintenance. As I said in all my videos, and I think it's relevant that I do that, there is no child maintenance holiday during the lockdown. You have to maintain your child. If you lost your job or you are getting paid less money, please make an effort. Please adhere to the specific maintenance order. If there's no maintenance order in place, please continue paying what you have been paying. If you really cannot afford to pay the child maintenance based upon an income perspective, please sell your cell phone, sell your car, sell whatever property you have to ensure that the minor child has enough food and clothing and his or her needs are met. If you really cannot afford to pay in terms of a maintenance order, then please approach the maintenance court as soon as possible and make an application for a variation or a reduction of the maintenance order. Default of that, you will be in breach of the maintenance order, and it is a criminal offense. Therefore, please ensure that you adhere to the maintenance order. As stated, if you really cannot afford it, you need to approach a maintenance court. And the same breath goes to mothers or primary caregivers. Either you can be a mother or a father. If during the lockdown you lost your job and you are earning less money, you need to make an application to court. Well, first request from the other parent for more maintenance. It would obviously be in the child's best interest. If, however, the other parent who is supposed to pay child maintenance refuses to do so or does not want to pay more maintenance, and you believe there is a case for it, he or she can afford to do so, to pay more money, then we advise that you approach a maintenance court as soon as possible for an increase in the maintenance amount. I did not deal with that much in the past, where someone requires more maintenance during the lockdown. I generally dealt with the issue concerning if somebody lost their job. But in the same breath, the knife cuts both ways. If you require more maintenance during the lockdown, either you lost your job or you're getting paid less money and you believe the other parent can afford to contribute a bit more, you need to get the other parent to pay more money. If he or she does not want to do so, approach the maintenance courts. If you have any questions, please pose it and I'll be happy to answer it. Regarding the issue concerning child custody, it seems to me there's a lot of queries going around, at least in our office, where people cannot seem to finalize the issue regarding child custody. Often, and bringing divorce into it, the parties might struggle to finalize divorce because the issue is the main issue that the parties cannot resolve is that of child custody, where the mother says, I want to have primary care or custody over my minor child, and the father says he wants to have primary care or he wants to have custody of the minor child, or he wants to have more contact than what the mother offers him. And that becomes a stalemate in the sense of the parties cannot finalize the divorce. Months go by, years go by sometimes, and the divorce cannot be finalized because of that issue. The same breath, child maintenance issues as well. Parties cannot finalize the divorce because the issue of personal maintenance, alimony, that's the, I believe, American term, but personal maintenance where a spouse claims maintenance from the other spouse, spousal maintenance, child maintenance cannot be resolved, and the divorce takes many months and sometimes years to be finalized. I will start on the issue on maintenance. If the parties cannot come to an agreement regarding maintenance, my advice always is agree on some reasonable amount. If the minor child is on a medical aid, that can continue. If you have been paying the school fees, continue doing that. If the only issue is that of regarding the cash contribution for clothing and food and petrol and so on, then leave that to the maintenance court. Finalize the divorce, place a clause into the settlement agreement stipulating that you reserve your right, or the caregiver reserves his or her right to approach the maintenance court in the future. However, you are finalizing this divorce for the sake of expediting the matter. That is a general clause that is stipulated in divorce orders where the parties have a stalemate. Regarding the issue concerning child custody, I do not believe it is in anyone's best interest, the parties, the husband and the wife, or the minor child, definitely not for the minor child, in the minor child's best interest, for a divorce to be dragged out, especially if the issue is that of custody. The parties are already living in separate homes. They are in some way or another exercising contact. There should be some type of an agreement, but to litigate and fight over the issue concerning custody, I believe it's just a waste of energy and a waste of time, and it cannot benefit much from that, unless there are very good reasons to do so. But most of the time, one party is being more stubborn, one party is egotistic, or sometimes both parties have those two characteristics, being stubborn and egotistic. You will benefit. The minor child is most probably 5 years old. You litigate for the next 3, 4, 5 years. What do you have to benefit from this? 3, 4, 5 years of your life just went away and nobody benefited from that. My advice on divorce matters are simplistic. Firstly, if you are married in community property or out of community property, with or without a accrual regime, whatever your matrimonial property regime is, there's no reason to fight over that. If the other party is entitled to half your pension fund, he must get it. If he's entitled to half the estate, he must get it. If the other party is entitled to nothing because you are married out of community property without accrual, then that is the case. So therefore, the propriety aspects of a marriage needs to be resolved without any litigation. Regarding the issue concerning child maintenance, it's a simplistic one. I do not know why people have to argue on it. Go to a professional, go to a lawyer, let somebody work out the mathematics. Put your income on the table, your expenditure on the table, the child's expenditure, both parties' income and expenditure on the table, and let some professional come to your assistance, either an attorney dealing with family law matters, an advocate, and so on. Get two opinions. Take it to one person, take it to another person. Go to mediation. Try to resolve the matter. It can only be so much. You cannot avoid paying whatever you have to whatever has to be paid. If the one party wants 10,000 rand and you're only earning 5,000 rand per month, obviously there's no case for 10,000 rand per month. However, if you're earning 50,000 rand per month, the child costs 5,000 rand per month, and the other party earns 10,000 rand per month, clearly you have to pay much more money, 10 times more money which the other parent is paying. Those are simplistic figures. Don't hold me to it. There are various other factors a person will have to have a look at when deciding what's a fair and reasonable amount of maintenance to pay. So that's a maintenance issue. Regarding care and contact, simple. You go to a social worker, you go to a somebody who knows child matters, ask them to investigate the matter, give a simple report, and then based upon that report, you finalize the matter. I see no reason why the parties needs to litigate on that issue. You're putting the decision into the judge's hands or the magistrate's hands 2-3 years later. 2-3 years later, the minor children have already been accustomed to a certain lifestyle, living with one parent and living with another parent. Therefore, on the issue concerning child custody, if you cannot resolve it, go to 2 different social workers, see what they have to say. Two different experts, see what they have to say. Try to mediate the matter. After giving it 2-3 months of, if the matter cannot be finalized, then obviously you have to go to court. But why is it not finalized if you have 2 reports? And most probably both reports will say the same thing if both parties were involved in the mediation process together. And if the report says the minor child should remain with the dad, that's the report, and you must just follow it. Who will benefit if you're going to litigate this issue for the next 3, 4, 5 years? Those are my comments. I see today we have no further questions. Yesterday we had a lot, and Monday we had a lot, and I had to cut it short. Thank you for watching this video. Much appreciated, and I hope you benefited from this. And we are looking forward to seeing you at our next live Zoom webinar, live Facebook webinar. Thank you very much. So let us now officially begin with the specific topic. If a child has not yet been born, in that regard, there is no child, there is no birth certificate, there is no name, there isn't much. All that we have is a child in the mother's stomach, in the mother's womb. That's all that we have. That specific child cannot lay a claim for maintenance against a third party. The child will first have to be born, and the matter can be dealt with on that specific basis. So therefore, child maintenance cannot be claimed while the child is in the mother's stomach. But at the same time, child maintenance, the expenditure the child or the unborn child could have incurred, for example, the birthing expenditure or hospital visits, etc., in relation to the child, obviously the father of the minor child has to contribute towards that. And that can obviously best be resolved once a child is born. Therefore, to repeat, if you look at the child maintenance application form, you will not see any section there on dealing with the unborn child. There will not be a section on there stipulating that is the child born or unborn. If the child is not born, please provide us the details with the estimated date of birth. No. When you complete the child maintenance application form, there's a specific section dealing with the name of the child and the date of birth of the child, and that's full stop, not the anticipated date of the child. I'm being very elementary, very basic, in the sense of I'm trying to explain to the listener who is Googling this topic in the future, who is pregnant, and who would like to have an answer on this. A quick answer to that is that you cannot approach a maintenance court for maintenance for an unborn child. What you should do, and that's the second part of this webinar, is keep a record of all expenses you have incurred in relation to that specific child, being it vitamins, being it a cot. Should the child be born, the child would require a place to sleep. Be it clothing, future clothing, be it hospital visits, gynecological visits, etc. Obviously, the issue of whether or not those expenses were reasonable and necessary at the time will have to be decided later on once you do approach a maintenance court. So to jump the gun, the maintenance court, when dealing with a matter the first time, can make two orders. First order would be maintenance going forward, and a second order the court can make is a contribution by the father for expenditure incurred in relation to the birthing of the child. So that's very easy. And also maintenance or expenditure the mother incurred in relation to the child until the application was made in the maintenance court, or when the matter gets finalized. Then the court will make a final order, let's move forward. So the court might make an order, for example, 10,000 Rand regarding the birthing of the child, and another 50,000 Rand for maintenance that the mother paid towards the minor children, or the expenses she incurred in relation to the minor children for the following year. And when the mother approached the maintenance court when the child was 1 year old, the court will make an order going forward, and that will be the amount of money the father would have to pay regarding child maintenance. So to conclude, I would advise people who are pregnant, congratulations, but at the same time, you may not approach the maintenance court for maintenance order. There is no child as such. It is unfortunate that you would have to bear the brunt of the minor children's expenditure until the child is born. That's very unfortunate. And hopefully the father will come to the table and he will stipulate, yes, I'm responsible for at least half the expenditure in relation to the minor child, and I will pay my half. Here's my half, or whatever I can contribute. But if the father says, no, I'm paying nothing, the child is not my child, I do not want to pay anything, or I cannot afford it, etc., it would not be sensible for you to approach a maintenance court, because there are these disputes. How does the court determine, or pragmatically, would the court be able to determine in time? It might take a few months for the court to make that decision. And once the child is born, then the whole inquiry changes, because now we're dealing with a different inquiry, not regarding the birthing expenditure or the pregnancy expenditure, as the case may be. Now we're dealing with maintenance going forward, and we have to deal with the past expenditure in relation to the birthing of the minor children. Therefore, long and short of it, please prepare your documentation, make sure that you record everything. And when you do approach the maintenance court after the child is born, you can clearly outline to the maintenance court, here are my expenditure in relation to my pregnancy, laying in expenditure, the birth of the minor child, and so on. And the court will be in a very good position to make a determination as to what the contribution should be from the father in relation to that. Let's say you approach the maintenance court when the child is 8 months old. You've incurred expenditure for the minor child from birth until that 8 months later. Obviously, then you'd want to record that specific information, keep the receipts, keep whatever you can, because when you approach a maintenance court, then the court will be in a better position to make a ruling as to how much the father should have contributed towards the maintenance of the minor child since birth and until when the court makes an order going forward. A person cannot be in arrears of maintenance if there is no maintenance order. What the person can be, the person has to obviously be responsible for a portion of his or her income of wealth towards the expenditure of the minor child. Therefore, if someone asks me what contribution should a father make towards a child, my answer would be based upon his income, the mother's income, the child's expenditure, and so on. There is no fixed fee, fixed rate, for example, or fixed amount stipulating that a father should pay only 50% towards a minor child's expenditure. There are a lot of variables, a lot of factors that plays a role. For argument's sake, clearly the age of the minor child. And the challenge I sometimes face when clients come to me where the child has just been born is that a child of a month old, compare that child to a child of, let's say, a year old, the expenditure will be totally different because, yes, both might still be on diapers, yes, they all require clothes, but the newborn child may only be on breastfeed or formula. So the dynamics are different as opposed to comparing a child of 10 years old and a 13-year-old child. The only marked difference could be possibly maybe one eats a bit more and maybe schooling cost, but it's more in the same, more or less in the same region. But a newborn to a toddler to a preteen to a teen to someone who's 17 years old, 17 years old maintenance. 18-year-old can claim maintenance, but generally we deal with scenarios where the children are under 18. And a 17-year-old, would cost different than a 13-year-old and so on. So therefore, it's important to keep records, keep your data, keep your documentation as best as you can. Therefore, in conclusion, I'll have to end this video shortly. To all the pregnant mothers out there who are watching this video and want to know, can I claim? Yes, you can claim, but you need to wait till the minor child first came out of your tummy, and then you claim for all that arrears. Pragmatically speaking, I would hate for a mother who's pregnant to go to the maintenance court and make a complaint. They'll ask you all those questions. They might just say, please, ma'am, we can do nothing. We do not even have a child. We do not have anything. And the father, especially the father, might say, he's disputing paternity. Alternatively, they might entertain it. I'm talking hypothetical. Then they subpoena the father to come back to court 3 months later. By that time, the child would have come out already. And your whole application might have to change based upon that. I hope you have a lovely day. Thank you for watching this video. I hope it assists some people regarding this specific topic of whether or not child maintenance can be claimed for an unborn child. You cannot make the claim there, but you can claim after the child has been born for those specific expenditure which you have incurred. Birthing expenditure, food, etc. Have a lovely day, and I'll see you online soon. Good morning. My name is Mohammed Abduroaf. I'm a family law specialist, dealing a lot in family law matters, making the life a bit better. And today I would like to interact with you, whereby we can deal with certain type of issues, and one of those issues are care and contact issues. The topic is how to win your care and contact case in the High Court. The reason why I'm referring to the High Court and not to the Children's Court, the Children's Court has a total different way of dealing with these type of matters. They are more, in my view, a court that are supposed to deal with serious issues where they could potentially place a minor child in foster care, in a place of care, remove the minor child from the parents, and so on. So they have their own procedures, their own way of dealing with custody and care matters and guardianship matters. So today we'll deal with a normal application, how to deal with your matter regarding care and contact in the High Court. Obviously, the principles that apply here could equally apply to the Children's Court as well. So you do not have to worry about that. I'm certain if I have to deal with how to win your care and contact matter in the Children's Court, that would be my topic. I don't think there will be much to discuss because there are other aspects involved as well. So welcome again, and please note that this webinar is streaming live on Facebook Live. That's one platform. People are posing questions. Thank you for that. I see 2 questions have come in now already. The questions on my whiteboard, on my screen, those are questions that people posed when they registered for this webinar. Those questions I'll deal with first. And we're also allowing live interaction via those who are on Zoom. If you're watching this webinar via Zoom, you are welcome to put up your hand and I will allow you to unmute your microphone and you can interact with me. The duration of this webinar is about 1 hour to 1.5 hours. We will not go beyond that. So hopefully within that hour and a half, I can answer all your questions and deal with whatever concerns you have. So I'll deal first with the questions on the whiteboard, and then I'll deal with the questions via Facebook Live, and then I will interact with you via Zoom if you have any questions. So your voice will be streamed into the webinar, not your face at all, and we'll take it from there. So let's start. The first question that was posed to the first registrant that registered for this webinar goes as follows. Hopefully you can see it. I think on the Zoom, to assist you via the Zoom, I will just share that specific screen so we can be on the same page. Hopefully you can see it now via the Zoom. The question goes as follows. If a parent gives up his or her full parental rights and responsibilities in respect of his or her children, can that parent at a later stage recover his or her parental rights and responsibilities? Looking at that question, 2 scenarios come to my mind. The one scenario whereby a party relinquishes full parental rights and responsibilities on not a divorce scenario, on an adoption scenario, whereby the parent signs away full rights and allows the child to be adopted by a third party, and maybe with the other parent as well. Let's say the other parent married someone else and wants to care for the minor child with the other parent, but the other parent, the new parent, the step parent, has no rights. Then the step parent decides to adopt this minor child with the parent he or she married. That's a one scenario. With regard to that specific scenario, my answer would be then you relinquished all rights and you cannot come later on and say, I would like to have my rights again. You've consented to adoption. You've signed off all your rights regarding the child. It is possible for an adoption order to allow for certain type of contact to continue post the adoption, but the adoption order will deal with that. Then I think specifically where this question deals with, not adoption, dealing with a normal scenario where a party might have approached the court and relinquished all parental rights and responsibilities in relation to the minor child. That was most probably done via an application to court, and one party said, I agree, or it was litigated, and the court made an order that that a specific parent has no parental rights and responsibilities. Then the question that is posed is, can that specific parent come back later and say, I would like to have my parental rights and responsibilities back again? My answer to that is, it all depends on what is best for the minor child. So the academic answer would be yes, it is possible, it is theoretically possible. Even if a parent has signed away or agreed or consented to relinquishing all his or her parental rights and responsibilities, for example, not being able to see the child, not having the authority to consent for the minor child to be, maybe get to go to a school, to relocate, to apply for a passport, he relinquished all that parental rights and responsibilities. He done it in terms of a court order. But 5 years down the line, he or she believes, I made a mistake, or now I actually want to be back involved in the child's life. Many reasons could be for that. A reason could be that after he or she relinquished his or her parental rights and responsibilities, the relationship between the parent and the child has become, changed, became better. For example, let's say this is a case where the father signed away his rights. The father now is more involved in the minor child's life. And he says, no, man, I am now very much involved in the child's life. Yes, I made a mistake in signing my rights away 5 years ago. I want those rights back. The court will have to reassess the matter, and if the court decides it is in the minor child's best interest, the court will make such an order. I hope that answers question number one. And if I did not, if you are watching this video via Zoom, you're welcome to later on call back in and ask me additional questions and we can interact. Question number two. My baby's daddy have not been supportive towards the kids, so I want them to sign parental rights to me. How do I do that, and is it advisable? I will maybe rephrase that question, and hopefully I'm rephrasing it correctly. The father was not much involved in the child's life. Now the mother wants the father to sign over his parental rights. Why would you do that? Many scenarios could come to my mind. One would be, for example, the father is hard to find. When she applies to schools, the father cannot be found, or he does not want to give consent. The father does not pay child support. He is not involved in the child's life at all. And at every corner, the mother has to consider, I now have to consider the specific father all the time, but he's not involved in the child's life. When I apply for the primary school, the father's consent is required. I must find him somewhere. I must lie to the school. I must say the father cannot be found, and the school maybe comes to my assistance. It becomes problematic. Now, a scenario like this, I will deal with in two ways. The first question I will ask you, is there a specific problem which you are incurring? Or do you want to, for your own mental sake, have something on paper? For argument's sake, if there aren't any problems, the father is not involved in the child's life at all, completely, but there are no challenges. There's no challenges regarding the minor child being enrolled to school. The school understands. There are no challenges regarding the minor child, consent for various things, for example, an application for a passport. So there aren't those challenges, but the father is not involved in the child's life. Now, the factual scenario, the factor scenario, or the factor facts, or the facts applicable here, would be that the mother is a primary caregiver of the minor child. She is theoretically exercising full parental rights and responsibilities over the child. The question is, why would she want to go to court if she is the one? Many people go to court if there is a dispute. If one parent wants to have care or contact, whatever the case may be, and the other party is disputing it, then you go to court, then you formalize it, and the court will make a decision. But here we're dealing with a scenario where the party has factually is a primary caregiver of the minor child. So, under those circumstances, I would say, why do you want to go to court? Why do you want to formalize it? In a few years' time, the child will be 18 years old, and then you wasted legal fees. However, if there is a reason why you want to do it, a basis, for example, there's problems, consent issues. I cannot leave the province because the divorce order which I had specifically stipulates I cannot leave the province without the father's consent, but I can't get hold of the father and so on. Then I would say it makes sense. So think about that question. You're welcome to pose any additional questions. When I said early on it made sense, then I would advise you to make an application to have sole guardianship right over the child. Question number 3. What is the process to follow when the other parent does not comply with the parenting plan that has been made a court order? Is it even worth laying a charge against them? This is a difficult question to answer based upon that, because I do not know what specific provisions are not being adhered to, etc. So what I mean is, are we saying that one parent is refusing another parent contact in terms of a parenting plan that was made in order of court? Remember, a parenting plan that is made an order of court is no longer technically a parenting plan, it's a court order. So it gets power after it was made an order of court. Then we're basically referring to a court order. Are we dealing with a scenario, I'll repeat myself, Are we dealing with a scenario whereby one parent is not allowing the other parent to act in terms of this specific court order? For example, the court order says the dad can have contact every second weekend. The mother is saying, no, you can't have contact, despite the court order, despite the parenting plan in the scenario. Or are we dealing with a scenario where the parent who is entitled to have contact, let's say you're the father, decides not to exercise contact? What happens then? So those are two scenarios. And the difficulty with dealing with these type of matters are that, yes, I see somebody making a comment, load shedding, and I think my network also gave me problems early on. So if I do get cut off, please let's log on again. I should go back online again. But the load shedding is a bit of an issue, or some electrical issues within the city or on the networks. Let me continue. So the second scenario, whereby a parent is not exercising contact, although he or she is entitled to, there's not much you can do where that is concerned. You can't necessarily go to the court and say, I'm laying a criminal complaint against the father because he's entitled to have contact every second weekend. He does not want to have contact every second weekend. He is violating the order by not having contact, but you can't necessarily force somebody. And I have a problem with that. You know, the law should force somebody to exercise contact. But then again, now they force a person to have contact. The person is rude to the minor kids. He does not really care for the minor kids. He drops the kids by his mother, his sister, his aunt, or leaves the minor kids alone at home. So doing that would be, but could possibly be problematic. However, if a parent is refusing care and contact in terms of a court order, a parenting plan that was made in order of court, that becomes problematic. And under those circumstances, I would advise you to lay a charge of contempt of court. So, for example, you're the father, the mother refuses your contact based upon a parenting plan that was made in order of court. Go to the police station, lay a charge of contempt of court. There's a criminal way of doing it. Go to the police station, or the civil way of doing it. You make an application to court. I hope that answered that specific question. Let's go to question number 4. As I mentioned earlier on, I'll be dealing with all these questions, question number 7 and what's on the Facebook questions, and then I will be interacting with my Zoom participants. So do not be shy, only your voice will stream through, and I think it's more meaningful because I can engage better. When posing the question, you are limited to a few words, few sentences. When doing the live interaction, you can go ahead, ask and I'll answer, and we can continue on that basis. Question number 4. This question is not necessarily a custody question, but because you pose it, I will deal with it. Is it reasonable to ask the court to consider pro rata adult expenses for the primary caregiver in relation to the partner for living costs? Example, pro rata rent versus 50-50. Now, my view always was that you do not decide on child maintenance amounts based upon fixed ratios, because child maintenance is dependent upon the means of the parties. The amount you pay is dependent upon your means. Therefore, it's possible for the mother to contribute 90% of the child's expenditure and the father 10% because she earns 9 times, also 90% more what the father earns. Therefore, I have an issue with 50-50. You have to look at the circumstance of each case. You have to spend time mathematically and work out what is a fair amount to pay. Because clearly, what if the mother earns a small amount of money and now she's ordered to pay half the child's maintenance expenditure, and the father earns loads of money but he's also ordered to pay half? The mother will be prejudiced, and she's also left with a challenge and the obligation of caring for the minor child during the week. Therefore, I am full supporter of pro rata. You work it out based upon the actual expenditure, based upon the facts applicable. I hope that answered that question. I'm not going too much detail on child maintenance questions, but I should have dealt with that. Question number 5. How does supervised contact get phased in? What happens if one parent needs to relocate due to finding better or permanent employment? So those are 2 questions. I'll deal with the first one first. Supervised contact getting phased in, I think here we're dealing basically with time-wise. So when does supervised contact in principle, supervised or not, get applied? The whole idea is basically to ensure that the child is safe, or psychologically safe, physically safe. Psychologically in the sense of, what if a child never saw the other parent for years, does not know the other parent? Mom has remarried with a new husband, new stepdad. Here all of a sudden the dad comes out of nowhere. He says, I want to have contact, which he has a right to do, but the child doesn't know the other parent. Must the other parent all of a sudden have contact every second weekend, every weekend? The child doesn't know this person. So clearly, phasing contact makes sense. Maybe we start with once a month for 6 months. Then we go towards twice a month. Then we go towards, maybe every second weekend. Whatever the case may be. But it needs to be phased in for the child's mental and psychological well-being. Remember, we're focusing on the child. We are not focusing on the parents. So I hope that specifically assists you where that is concerned. I need to do something. I'll stop the sharing quickly. And we can continue with the questions. There it is. But here we're dealing with a scenario of supervised, phased in contact. Now, when will it be supervised? For reasons I mentioned early on. Alternatively, if it's a young child, the child is not used to the other parent. And there needs to be somebody close by to ensure that the other parent can, properly engage and, deal with the child. So supervised contact does not mean you need to be in the same room watching the other parent. And the moment the child, makes a small sound, you need to come and reprimand the other parent and say, how can the child is crying, give the child back to me? And no, that's not how supervised contact works. You need to be in close proximity. If there are social welfare issues, if there are serious issues like, sexual abuse, physical abuse, and so on towards a minor child, then I would say you need to watch. But if it's a normal scenario whereby the parent is not used to the child, let the child cry for a minute or two, because that's the only way the child will get used to this person, and this person will get used to, the parent will get used to caring for the child. You cannot hop up and the moment you hear the child cries, come in and try to rescue the child. The same way, any parent, any experienced parent out there, grandparent, etc., knows kids cries. And you can try whatever you want to do. If the child wants to cry, the child wants to cry until the nappy is changed, until the child is fed. Therefore, you need to give that parent the opportunity to be able to learn and teach himself how to deal with a specific child. The same way, you can be an experienced parent with your kids. Give you another person's children, you will struggle for a few days or whatever amount of time to get used to that child. So that's where supervised comes in. So phasing supervised contact, as I mentioned earlier on, the idea is to let the child be accustomed to you and be used to it, and it does not psychologically affect the child. And it might have to be reviewed a few times. Being supervised, I would say, depends upon the child's age. It's very important. And at the same time, you need to give the other party an opportunity to develop certain skills, because the idea ultimately is for the child to be alone with the other parent and supervision not to apply anymore. Let us move on. Question number 6. Yes, that's it. Need help to get maintenance from the father as well as an exception at school. Another child maintenance question. You need to approach the maintenance court as soon as possible. So which court do you go to? You go to the court where you live, you and the child lives, or you go to the court where you work, wherever you work. That's where you go to. And you apply for child maintenance. The court will obviously ultimately call the dad in and look at your income, your expenditure, the child expenditures, and the other parents' income and expenditure, and the court will come to a fair amount. That's it. That's the long and short of it. So my advice to you is approach the child maintenance court as soon as possible. Let us move on. Question number 7. What are parental rights of unmarried fathers who are staying with the mother before the child was born and 2 years later? What are the limitations of the children's court with regard to primary residency? So the scenario, if I'm understanding correctly, mom and dad, they live together, mom fell pregnant, child popped out, beautiful, everybody's happy, they stay together for another 2 years, father was involved in the child's life, the relationship ended, put it that way, and they're no longer together. And now the question is, what's the limitations of children's court with regard to primary residency? Oh, the first question is, what are the parental rights? So in terms of the Children's Act, if you are married to the mother of the child, if the father is married to the mother of the child, automatically the father has full parental rights and responsibilities, meaning he has to be consulted and his consent is required regarding passport applications, relocation, those important things when it comes to a minor child, application for his school, etc. He has a right to say, I want to have contact with the child and to be involved in the child's life. That is it. And if the mother automatically by default, she has full parental rights and responsibilities. The question is the dad. But we have a problem here. We can't cut the child in half. Once parents have separated, things are different. The father might live 10 kilometers away, 50 kilometers away. The father might have a certain schedule. The mother might have a certain schedule. The father may not be able to change a diaper. He might not have any experiences on how to medicate the child. Factors are different. Families are different. Everything is different. We can't cut the child in half. Therefore, we need to come to some type of a resolution. Although both the parents have full parental rights and responsibilities over the minor child, regarding the care and contact arrangements, that has to be workable under the circumstances. So in answering your question, yes, the unmarried father here has full parental rights and responsibilities with the mother, and we hope that they can come to an agreement. Okay, this is your weekend, this is my weekend. No, we skip this weekend because there's a wedding in the family. We skip that weekend because I need to be overseas. I need to do something. I don't know. The parties are amicable, they're understandable, they're reasonable as any person would be. The same way you're working at your boss, at your work. Sometimes your boss and you come to some type of a discussion regarding some issue. So maybe, for example, whether or not you can come to work or whether or not you shouldn't come to work, but you guys come to an agreement. The same way regarding care and contact in relation to a minor child, the parties need to come to an agreement. But if they cannot come to an agreement, the court will get on board and the court will say, under these circumstances, considering the mother's schedule, the father's schedule, everybody's schedule, the needs of the child, the age of the child, what school he goes to, how far the school is, extramural activities, needs of the child, etc. One parent only has many people living in the house, therefore there's no bed for the child. However, contact could take place every second weekend, but the child will obviously have to come back to the mom during the night to sleep. So whatever the factors are, although you are co-holders of parental rights and responsibilities, a workable solution has to be implemented. And if you cannot agree on that, you and the other parent, the court will get on board. And I think I answered that question. And the limitations of the Children's Court with regard to primary residency, no, the Children's Court can make an order regarding that. There are no limitations regarding that. That was the last question that was posed to us via our registrants. And we had now 2 Facebook Live questions. I'm looking at it now, and I will deal with the first one, which I have in front of me. The question goes as follows. What does a woman turn to for help when organizations and governments only refer you in circles trying to save your child and protect our rights? Everyone is fundraising, but they only send you to legal aid, zero assistance. Yeah, this is a very difficult question to answer. Lawyers generally, they study, they finish their studies, they get trained, and they open up a business, and then they charge for these services. And some of them will do community work, maybe like webinars like this or whatever. And there are other organizations like Legal Aid and Legal Resources Center, where those lawyers are also earning a living, but the organization itself is paying them. Now, the challenge you have is that one party might be able to afford private legal assistance, he's paid for his own lawyer, and the other parent would not be able to do that, and he or she must either represent himself or herself, alternatively make use of organizations like Legal Aid, etc. I do not know how to answer this question, but it is a concern to me. I believe honestly that the children's courts, the maintenance courts, the domestic violence courts should have lawyers there employed by the state to assist people with these type of problems. The criminal courts, you'll find it all the time. Most courts in Cape Town, there will be, sorry, in South Africa, they will have a specific legal aid practitioner at the Pacific Court, appointed to that Pacific Court room. And if you are being charged for a certain offense and you appear in that Pacific Court, there will be a a legal aid representative in that Pacific Court or dealing with that court, and you can apply to the legal aid board and they will appoint your case to that specific person. But it seems to me on children's matters, etc., they just appoint the maintenance officer to try to assist you, or there are some clerks. But I honestly believe that should be the case. I don't know how to answer that question. It's a government question to answer. And I hope you do find some type of relief or help out there. I believe everybody is entitled to have very good legal representation when it comes to these type of matters. Unfortunately, for any profession, accountant, a doctor, a teacher, we all have, have to earn a living. But at the same time, there are organizations out there whereby they are fundraising and they are obtaining funds from the state or various organizations who are out there to assist you. That is why they are there. Put it that way. Okay, we have another question on the Facebook Live. I need to get to it quickly and I need to copy and paste it into our chat. Let me get it there. And please remember, you are welcome to put up your hand now already if you want to pose a live question via the Zoom platform. I'll be happy to do that for you, answer it for you. Okay, let's get to this question. Before I deal with that, let me see if there's anyone else who wants to join our Zoom. I think we're doing well on the Zoom. Perfect. The next question on Facebook Live goes as follows. If a parent refuses to sign school admission forms and any other form related to consent by both parents, can one apply to have the particular parent removed from the birth certificate as that parent? I do not think you can be removed from the birth certificate from that parent because that's a factual thing. You're the parent. Taking your name off the birth certificate does not make the child not having a mother or not having a father. You always have a mother, always have a father. So it's almost like someone asking me, they were married, they got divorced, can I change my details that I was never ever married or I was never ever divorced? You cannot do that. So changing the name take the name off the birth certificate, that doesn't make logical sense because then you say there is no father, the father is non-existent, or the mother is non-existent, there was no mother. It happens differently, either artificial insemination, whatever the case may be. But be that as it may, what you would want to do under those circumstances is approach the court and have the court appoint you as a sole guardian of the minor child. So you have two options. The court can either say no, keeping the father or the other parent, as a co-guardian over the minor child, but under these circumstances, for this specific case, for this specific school, for this specific enrollment into the school, mom, only your consent is required. And the court makes an order and you show the order to the court, to the school will comply and they will admit you based upon your consent only. However, if you see this problem arising every single year or for extramural activities, for passports, whatever the case may be, I do not know, you might want to approach the court and say, these are the difficulties I'm having. Every single month or every few months I have a problem, judge. I cannot approach the court every time. Please take away the other party's guardianship rights when it comes to these specific aspects so that I can parent the child much, much better. I hope that specifically answered that question. And if it did not, you are welcome to make use of the Zoom. If I do not receive any questions via the Zoom, any hands going up, then and no further questions on the Facebook Live, I think I have a question on the Zoom, a typed question, and then we'll have to end the webinar and get ready for the weekend. Okay, let me get to the Zoom question so that everyone can see it. Here it is. The question is as follows. I see there are a few questions. If a parent refuses to sign school admission, that was a question I got earlier on. My apologies for that. Let's go to the next question. I must be very manual here. I need to copy and paste. Okay, that's it. I'm seeming to have some problems copying it. Hopefully it'll work. Nope, it doesn't want to copy. It's very weird. You know, I'll read it out directly and we can take it from there. Me and my wife separated after she falsely laid a charge of assault against me, which she later withdrew. Okay, that's fine. She took the kids out of the home, I presume, in 2018, September, to the family home and enrolled them at a new school. I took the kids back in 2020 and enrolled them back at the previous school at my home and sent the elders to boarding school. I informed her even though she did not agree. In 2020, she never made any effort to visit the kids or ask the kids to visit her. I then reached out and the kids needs to see her. Reach out to her and asking her that, telling her that the kids need to see her. I took the kids to her in December, and when they were supposed to come back, she refused to return the kids, I presume, and wanted a family meeting to resolve our issue. She ended up enrolling the kids again in another school, and on my side, I am yet to deregister the kids pending the court process. Okay, I see where we're going to with this. The case is now at Children's Court after failed mediation from the Family Advocate Court. Should the court rule in favor for the kids to be returned back to me, do I let them finish school there or re-enroll them back at their school? Okay, that's a question. So the parties were in and out of court. The child was living with a mom, with a dad, mom and a dad. So the kids last lived with the dad, and they went to go visit the mother. The father reached out to the mother, and after the kids lived with the mother for a short while, she decided not to return the kids and enroll them at the Pacific school wherever they are residing. I presume this all happened now this year, of course, and they were now at school for the last 3 weeks or 4 weeks at the mother's new residence, or at the mother's residence or the mother's province, whatever the case may be. The question basically is, if he is successful at the court application, is it best to have the minor children remain where the mother is residing or return back to him? I would say strongly have the children return back to him. The reason for saying that is, if the minor children continue residing with the mother to finish a school term or finish a school year, whatever the case may be, then that becomes a new home. They are now rooted there. Things are developing. The kids aren't attending school and telling the teacher, don't advance me too much because I'll have to go back to a different school in a few months' time, to my dad. Or don't enroll me for tennis, for netball, for swimming, for rugby, for soccer, for cricket, because I will be going back there. So my advice to you, if you are successful, this is from a strategic point of view. If you are successful, ask the court that the minor children be immediately returned to you and they continue school where they are at. If that is not the case, the children will be obviously advantaged in the mother's favor to live with her, and she can bring up a very strong case at the end of the year stipulating, you know, judge, thank you, you made an order previously, but now that things have changed, new circumstances, it might be best for the kids to actually to remain with me. That's from a strategic point of view. But seeing that we're dealing with minor children issues, matters regarding children, it is what's best for the kids. So if it is best for the kids to live with the mom and to continue schooling there, and the professionals are recommending that, then I would say that should be the case. I have a question over here. I think it refers to the previous webinar. I emailed you last week. I do not recall receiving an email, but if you have emailed me last week, please re-email it or give us a call at the office and I will respond to that. My apologies if I didn't see that email. Additional question, I have been working with a social worker and facilitator. The sessions and outcomes seem to be centered around the parents agreeing versus the voice of the child. During social worker visits, should one approach the family advocate? So when you focus on when you're dealing with mediation sessions, or facilitation and so on, the focus is generally trying to resolve the matter between the parties. The parties need to resolve this matter, and the parties are the best parties or people to decide what is best for them. And if they can come to a solution on their own, which the facilitator might think it might not be best for the child, but the parties are coming to it and they will work towards making it work, then that ultimately, in my view, is best for the child. For argument's sake, if the parties come to an agreement that the dad will pick the child up at 4 o'clock in the morning and drop the child the evening at 10 o'clock the evening, for argument's sake, and the mother is happy with it and she thinks, it can work, it's workable, because maybe the child will fall asleep during the day, but the party said this will work for us and it will be in the child's best interest. The facilitator might think no, it's not, but it's not for her to decide that, because now she said no, I think you should pick the child up at not 4 o'clock in the morning, but at 8 o'clock in the morning. What does that entail? It means the father must change his work schedule, the mother must change her work schedule, she must be available at different times. All those type of technicalities or issues might arise because a third party is now getting involved as to what should be in the child's best interest, but the parties themselves found a solution. Under those circumstances, I would advise that the parties, that you do not need to take the voice of the child approach, because we're dealing here with facilitation. The only time you actually do take the voice of the child approach, from a very strong point of view, is when the party matter cannot be resolved, and now you start listening to what is best for what the child has to say regarding the specific matter. But if the parents, who are the parties who will be implementing the specific plan, will be the one caring for the children and the one that's dealing with these specific scenarios, they are best to decide what is best for the mind of the child and for them. But as I mentioned earlier on, if there is a dispute, if the parties cannot come to an agreement, etc., then we need to start listening to the child as well. Strongly listen to the child. I hope you follow where I'm going to regarding that. And the last question on the specific questionnaire, should one approach the family advocate? The family advocate will most probably try to mediate this matter as well. But the family advocates, my understanding is they do not investigate unless there's a pending court case, whatever the case may be. It will be silly for them to investigate a matter, every single matter that comes to the table, unless there's a pending court case and there's a purpose behind it. But they do try to mediate. So if the parties cannot come to an agreement, is unable to come to an agreement, and the matter is pending in court, then I would say yes, maybe ask the court to ask the family advocate office to investigate these issues and provide recommendations to the court. And based upon that, they will consult with the kids. But at the end of the day, they want to come to a solution that's workable for everybody. I hope that answered that specific question. I have additional question. The parent, I need to get to it. The parent who has primary custody has been brainwashed. The child of 11 years old, and the child does not want to go to the other parent. How would you handle this? The parent is also overclaiming the child's support. Okay, I read it verbatim because I don't have a chance to read it before the time. But be that as it may, the question basically goes here is 11-year-old child, one parent is brainwashing the child to say, you shouldn't go visit your dad, or please don't want to visit your dad. So whatever the parent tells the child, at the end of the day, the child comes to the opinion that I do not want to visit my dad or my mom. I do not see any genders over here. And then the other parent is also overclaiming child maintenance. So there are two issues over here. We're dealing with parental alienation, very difficult situation. You need to, there are two ways of dealing with this. If there's a court order in place, you just enforce a court order. That's all that I'm saying. The child should not have a say over how contact should be exercised. For argument's sake, let's say the child lives with dad. Dad smokes cigarettes, he drinks. Life is good there by dad, and McDonald's and Kentucky, whatever the case may be. The child said, no, I want to be with dad, I don't want to be with mom. But at mom's home, there's schoolwork, there's homework, there's routine, there's well-being, they maybe do some yoga, you never know. There's sporting activities, there's everything that is good is at mom's place. But everything that's fatty and greasy and fun is at dad's place. Now the child says, no mom, I do not want to live with you anymore, I want to live with dad. because life is good here, but only good on weekends. Should we now listen to the child? Should we now take what the child wants? So if there's a court order in place, the child must go back to mom, finish, done. However, if there are certain issues, social welfare issues, then we can relook the matter. But there must be basic valid reasons therefore. Regarding the overclaiming of child support, she's welcome to claim whatever she wants to. She can claim for R1 million a month if she wants to. It does not mean the court will grant her that. The court will only grant you what you are entitled to based upon all the facts of the matter. Okay, so we're now 41 minutes into the game. I have an additional question. What happens when the child chooses not to be with the other parent? The child cannot choose. Let's say, for argument's sake, we have a baby, and the baby is now with a mommy, and the dad can care for the child. Now the child does not want to go to the dad. Does the child choose? The child might choose now on a Monday night, on a Sunday night, no, I want to stay with dad. I don't want to go to school the next day. So the child cannot choose. The child shouldn't be able to choose. We listen to him. If there are serious reasons for why the child does not want to go to dad, molestation, abuse, then of course we listen to that. But if it's because of the child's preference, then what's the use we have court litigation? Then at the end of the day, it means the child must be the only one that goes to court, and he must say, I want to be with mom, I want to be with dad. It's a parent that makes decisions. And at the same time, let's say there's a birthday party. At dad's house, he has extended family, wonderful. Some cousins are living there. He lives with his family, his sister, and his nephews and nieces living there. So there's a birthday party on the Sunday. It's lockdown, meaning that those kids in that specific house will not be going to school the next day because that's the day off. We all know how this country runs education during the lockdown. Now, those specific nephews and nieces are saying, no, tomorrow, because it's not school and it is our birthday, we are going tomorrow morning early for a swim to the beach, and we come back to do schoolwork. The child says, no, I want to stay with dad because tomorrow they're going a bit out. But the school tomorrow for the child, even he's going to, because that's his part of his roster. Should we now focus on the child? The child should keep quiet. The child should just follow what the court order says. That's my quick answer. But if there's social welfare issues, that's something else. If the child says, dad, when I'm at mom abuses me, assaults me, whatever, then the father needs to act on it. He shouldn't just listen to the child, make a decision. He needs to go to the police, social worker, go to court, whatever the case may be. And I think that is it. I see no additional questions on the WhatsApp or on the Zoom, sorry, on the Facebook or on the Zoom. Now I am not dealing with any additional typed out questions. If you have any, if the participants want to pose any live questions, you're welcome to do so now. Please put up your hand and I will entertain you for that specific purpose. If not, I think we'll have to end the webinar and call it a day. So if you have a question, please put up a hand and I will let you call in. I'm getting my screens in order here. So Zoom participants, if you don't have any questions, I will take it that we're all happy with today's webinar and we can proceed. Okay, I see one final question. I'll answer that question. If I don't see the hand going up, I will end this webinar and I will thank everyone. Okay, is it compulsory to have a therapist report for a high court application? It's not compulsory. If the court can make a decision based upon all the facts and it's not necessary, then you do not have to have a therapist report, meaning having a professional to recommend to the court. However, it depends on the circumstance of the case. If there are serious allegations of one party being unable to care for the minor kids and so on, then I would say yes, it makes sense. But it's not by default always necessary for that to be the case. Okay, I see a hand up over here. Wonderful. Okay, the person whose hand is up, you are welcome to start speaking, and I'll be listening.
Okay, thanks for the opportunity, Advocate. It's just a follow-up to the question I posed on the Zoom with regard to the separation of me and my wife in September, to say currently we are waiting for the outcome of the social worker visit to both residents. My question was, is it advisable to say at the scheduled hearing, which is on the 30th, to involve an attorney to be part of that?
Yeah, I'll stay on the line. I'll answer you quickly on that, and I think I might have a few questions for you as well regarding that. So let's deal with this first part of it. So my advice to anyone is to always, if you can afford it, to make use of legal representation in these type of matters. It's highly complicated, and if you want to get the best possible results, solely because it's very emotive, you appear at the courts, and the other parent, you might have been involved in some domestic violence, some bad relationship, whatever the case may be. So it's always good to have a lawyer. That's from an emotional point of view. But from a strategic point of view, the lawyer obviously understands the law. He understands the Children's Act, the case law applicable to it. He understands procedure, which is extremely important, and how the courts work and what the courts look at. I tend to have a problem with my clients always what I believe as a professional, as an experienced lawyer, that's relevant in a court scenario. They believe the total opposite is relevant to the specific court case, and they're wasting time in court, and they're wasting a lot of energy. So if you have a lawyer, the lawyer knows what to focus on and what to be successful in your case. Please, if you have any additional question regarding that, the Pacific commenter, please go ahead, and I'll try to assist you.
Okay, sorry.
Well, if I didn't answer your question, you're welcome to add additional question to that.
No, I think you did. Thanks.
You are welcome, sir. Thank you for your comment. If there are no, yes, I see another. No, I don't see any other hands going up over here. If there are anybody else who wants to pose a question, please put up your hand on the Zoom, and I'll deal with it live. If not, I think we had a very successful webinar today. Unfortunately, I couldn't promote it earlier. I just got a slot this morning. I had to be in the High Court this morning, and the matter got settled. And I've managed to set up the Zoom with 2 days' notice. Otherwise, I would not be able to do it today. But thank you very much for all those participants, those persons who have posed questions before the time, those watching it via Facebook Live, those questions which the typed out questions via the Zoom platform, and also the caller that Pacific called in now and posed your Pacific question. Thank you for that. I believe that the more questions I get, the more opportunity I get to answer those questions and to enlighten someone, and someone will benefit from that. Thank you very much for your time. Have a wonderful day, and I hope to see you at our next webinar. Welcome again to our webinar dealing today with the issue of, is it possible for grandparents, aunts and uncles to have parental rights? Now, the default position is as follows. A mother will always have full parental rights and responsibilities over the minor child by default. The other position is that of the father. The question is, does a father have parental rights by default? Not necessarily, not always. If he was married to the child's mother, wonderful, no issues. He has parental rights and responsibilities over the minor child with the mother, and just as much as the mother has, because he is married to the mother. If he is not married to the mother, then we're dealing with a second scenario. The default position is he does not have any parental rights. However, he can acquire those parental rights. In short, I won't deal in detail with the Children's Act, but if he is involved in a minor child's life, supports a minor child, pays maintenance, or tries to do it, despite the mother making it hard for him to do so, he's actively involved, or he was actively involved in the minor child's life. When him and the mother was in a relationship, when the mother and the father was in a relationship, and the child was born, the father was there, he was involved in the child's life, supported the mother, supported the child, etc., and they've broken up, they've separated, he would have acquired those parental rights and responsibilities. A technical point, why does all fathers not have automatic parental rights and responsibilities if he was not married to the mother? Of course, there are many scenarios. One would be he made the mother pregnant and he went missing. He comes back 10 years later and say, I want to have parental rights. No, that doesn't work that way. He has responsibilities here to maintain the child. Or a very bad example, but a severe example, if he raped the mother. The child was born non-consensually. Under those circumstances, obviously, the father can't come here and say, oh, I want parental rights and responsibilities by default. Comes back here 5 years later and says, I'm the father, I'm the biological father, let's do a paternity test, and automatically, I want to see my child, I would like to have contact with my child, despite those specific circumstances. Therefore, the default position, as I mentioned earlier on, if you were married to the mother, automatically you have parental rights and responsibilities, you have right of care custody, you have a say in the child's life. If you are not married to the child's mother, automatically, the default position is you do not have parental rights. However, you're quiet by being involved in the child's life. That is very important to note. If you're involved in the child's life, pay child support, contact with the child, actively involved in the child's life, you would have acquired those specific rights, and you have a say in the minor child's life. If there's a dispute between you and the mother regarding that, the dispute can be taken to the office of the family advocate, and they will try to resolve that dispute. If they cannot, and you do not agree to that, and the mother doesn't agree to that, of course, the matter should be taken to a court, and the court can make a determination as to whether or not you have acquired those specific parental rights and responsibilities in relation to that specific minor child. Another issue, of course, a father can come out of nowhere and say, I'm the father of the child, I have parental rights, but you are not married to the mother. So issues of paternity, etc., must first be resolved. And once it's resolved, we can deal with the matter accordingly. I have 2 questions, but before I deal with those 2 questions, the reason for me dealing with a specific topic is that I am receiving a lot of queries. A lot of people are coming to me for advice on the specific topic regarding whether or not a third party is usually an aunt, grandparents most of the time, who wants to acquire parental rights and responsibilities, or the legal term would be the assignment of parental rights and responsibilities upon them. A usual scenario would be the parents themselves are not fit and proper, and the minor child is being cared for by an aunt or an uncle or the grandparents, depending upon either paternal or maternal. And the grandparents feel that they have an obligation to look after these specific children, and they want certain parental rights over the minor child or responsibilities. For example, they would like to enroll the minor child into a school. They keep on getting the problem, where is the parents? You are the grandparents. They can see the grandparents are a bit old. It's obviously not their biological child, their biological grandchild, of course. We're having 60, 70-year-old people coming to the doors of the creche saying, I would like to enroll the child. Clearly, you're not the parents. But however, some grandparents look very young again, and that can maybe pass. But nonetheless, you know where I'm going to with this. Aunts sometimes come to me where they stipulate that, her sister passed away, and the child has been cared for by her for the last few years, and she would like to continue those specific rights. Remember, our topic does not deal with the issue concerning adoption of minor children. That is a total different topic, total different issue, total different scenario. I'm not dealing with that. I'm dealing here with the situation where a third party would like to acquire specific rights and responsibilities in law, on paper, stamped by the court, and should they act, they are acting lawfully on behalf of the child. Should the child want to acquire a passport, leave the country, those specific persons who acquire those rights can sign or needs to give consent where that is concerned. Let us deal with the first question. It goes as follows. I am the maternal grandparent of 2 minor children. The mother went missing and the father is a drug addict. Is it possible that I have custody and guardianship rights of the minor children? Yes, it is possible. You have to acquire that, and you have to prove to the court that it will be in the minor child's best interest. Now, because you're asking for guardianship rights, only the High Court can assign guardianship rights over you. Remember, guardianship rights deals with the legal aspects. If you watch my previous videos, you will know that care and contact, custody issues are 2 separate issues. Guardianship issues are as well different. Guardianship deals with legal aspects. A parent can have sole guardianship and have no rights of care and contact. Cannot see the child, but he has guardianship rights. His consent is required for the child to get a passport, to leave the country, to purchase, to alienate property, go for an operation, etc. His or her consent is required, but he cannot see the child for whatever reasons. That is possible. It's a given scenario. Therefore, you have to prove to the court that it will be in a minor child's best interest for you to be assigned guardianship rights and care and contact rights for the minor child. The court will listen to everybody, maybe the family advocate's office, etc. Then the court will make a determination. So it is possible, and it happens regularly. I deal with it a lot. Oops, sorry about that. I deal with it a lot, and the courts make those specific orders if it is in the minor child's best interest. So the court will assign those rights upon you. The second question, my sister passed away during childbirth. She was married to the father at the time. I cared for the child since birth. The father now wants to take the minor child away. What can I do? Typical scenario, which I deal with on a regular basis. Child passes away. The father cannot care for the child. The aunt looks after the child. Quite some time goes by. The parties, for some or other reason, cannot co-parent the situation because the aunt, for example, she thinks it's her child and she acts that specific way. You can't blame her. And the father is the one that sees the child maybe every second weekend or visits or phones now and again. And there's a problem, there's a conflict. The court will obviously have to deal with this matter as to what is in a minor child's best interest. And if it is in a minor child's best interest for the aunt to be assigned rights of guardianship, care and contact, the court will make such an order. So the take home is it is possible for a third party, aunt, uncle, friend, could possibly be a ex-spouse. He or she can also apply for that. The parties divorced already. They had a child. Sorry, they never had a child together. There was a child of a previous relationship and they looked after the child. They've divorced, but now the step parent or the ex-step parent wants to still be involved in the child's life. He can apply or she can apply to court for the assignment of certain rights and responsibilities to the minor child. Thank you very much for watching this video. I hope it assisted you in understanding this topic, and I hope to see you online soon. Have a lovely day. Thank you. Bye-bye. Good morning. I trust you're all well and we're all safe at work or at home or wherever you are. And welcome to our live webinar. Today's topic, international relocation, passport and consent issues. The reason for choosing this topic is because we received a lot of feedback on our last video dealing with the same issue, however, dealing with the Children's Act, and quite a few people had some questions and comments on this topic. I can understand why it is of interest. People are now deciding to relocate, leave the Republic of South Africa and live abroad, either for work, family commitments. Someone might have married someone who lives abroad, or for a better life overall. Whatever the reason is, it is something which we'll have to obviously deal with. If you as an adult want to leave South Africa on your own, you're welcome to do so. However, if there is a minor child involved, you have a child with someone else, and now you'd like to leave the Republic of South Africa with that specific child. The child is younger than 18 years old, 17 or below. Obviously, under certain circumstances, the consent of the other party would be required. Now that becomes a bit challenging because if the other party consents to the relocation for you to leave the Republic of South Africa to another country, what does that mean? It means the parent who remains in South Africa will no longer have face-to-face contact with a minor child. That type of contact can only take place if the parent travels overseas or the child travels back to South Africa for a visit, and it will not be as frequent as it would have been under normal circumstances. Obviously, each family is different. Normal for one family might be seeing the child once a month, once every 2 months, once a year. And for another family, normal or reasonable under those circumstances would be seeing the child every single day of the child's life. Nonetheless, relocation has far-reaching effects on the family unit, the ability of the child to see the parent who remains in South Africa, and vice versa. If you are watching this video, this webinar live, you're welcome to post any question on the Advocate Mohammed Abduroaf Facebook page. That is the platform which I'll be using to answer any questions. However, if there aren't any questions, I will just go ahead and finalize these 3 questions, which are quite prevalent when it comes to our blogs and emails we receive on a regular basis after people have watched our videos. Question 1. Why is it necessary to obtain the consent of the other parent should I wish to obtain a passport for my child? Obviously, why would you want to get a passport? It would be to leave the Republic of South Africa. I do not see much use other than maybe identifying yourself at the bank, at the school, wherever you are, to say who you are, making use of a passport. The picture is on there, your name is on there, and so on. However, the most logical use of a passport would be if you want to travel to a different country and to show the border control, I am from South Africa and I would like to enter into your Pacific port. Nonetheless, why do you require the other parent's consent? Now, the quick answer would be in terms of the Children's Act, Section 18, you require the other parent's consent for the minor child to obtain a passport. So both parents have to consent for the minor child to obtain a passport. Now, both parents will obviously have to be guardians. If one parent is not a guardian, if the mother fell pregnant and the father, let's say use that example, the father went missing, the child never saw the father, the last time the mother saw the father was when the parties conceived the child, and then, or before the child was born, father was never involved in the child's life. 5 years later, 10 years later, of course, that father would not have any guardianship rights over the minor child unless he was married to the mother at the time. So, mother fell pregnant, father was never involved in the child's life, the mother was never married to the father. That father will never have any guardianship rights. He can acquire those rights. So obviously, if that specific mother wants to apply for a passport for the minor child, she does not require the father's consent. However, problems sometimes arise. When the child is born, the mother might have put the father's name on there as a father. And furthermore, Home Affairs might require to know where is the father. Now the mother comes with a long story, the father cannot be found, etc. And should they believe the mother? Maybe the mother is lying, we do not know. So those are sometimes complications that could arise. But that specific father does not have guardianship rights and therefore his consent is not required. If there is a problem, obviously the court can step in. The court is convinced that this father has no guardianship rights and he has no rights to the minor child, and the court will obviously authorize the Department of Home Affairs to issue the passport without the father's consent. So, answering that question number 1 would be because of the Children's Act, and of course for various reasons. We have this issue concerning child abductions, international child abductions, parents having problems, mothers leaving the Republic of South Africa without the father's consent, without his knowledge, because they had problems, So it makes logical sense if a child wants to get a passport and to ensure that everything is legitimately done, that both parents get involved in the equation. Question number 2. What can I do if the other parent does not wish to consent for the relocation of the minor child to the United Kingdom? So obviously, we use the United Kingdom in the scenario. We can apply it to China, Brazil, Cambodia, the Netherlands, Australia, anyway, any other country, because you are leaving the Republic of South Africa. There again, the Children's Act specifically stipulates if a minor child should leave the Republic of South Africa, the consent of both guardians would apply. I apply exactly the same scenario early on. The father's consent would obviously be required if he has guardianship rights. Please note, mothers always have guardianship rights by default. The only way the mother's guardianship rights can be taken away is obviously if the court makes that order or the child gets adopted by other parties. Those are the basic exceptions to it. So the mother will always have guardianship rights, but the father would either have it by default if he was married to the child, to the mother of the child, if he was involved in the child's life and not married to the mother, he can acquire those rights. But if he was nowhere to be found at the birth of the child and he only surfaced years later, at that specific point, he would not have any guardianship rights. He can acquire it by being involved in the child's life, maintaining the child, etc. He will acquire those rights. So, in answering question number 2, because the Children's Act says his consent is required, the father's consent is required, and if the father does not want to give wish to give consent, or wants to give consent, or is opposed in no uncertain terms to the relocation, then the mother would obviously have to approach the court, and the court, as upper guardian of all minor children within its jurisdiction, will determine whether or not it would be in the minor child's best interest for the relocation to take place. Okay, so the quick answer would be because of the Children's Act and because the father, of course, the guardian of the minor child. The third question, if I do not know where the other parent is it still possible to relocate to another country with my minor child? Very interesting question, something which people do not necessarily think about or of being a possible scenario, but nonetheless, it is a possible scenario and something which I dealt with quite a few times, where the mother comes to me and the child is 14 years old or 13 years old. The father was never involved in the child's life. The last time she saw the father was when the child was 2 or 3 years old. She might have divorced her father years ago. They went on with their lives. Life went on. Father went missing. She does not know where the father is. He does not have a Facebook account. He does not have a Twitter account. He doesn't have various social media accounts, which people are using nowadays. It changes all the time. And she doesn't know where the person is. She just knows that this person has a sister somewhere, but she cannot get hold of the sister. Or when she contacts the sister says, I do not know where my brother is. What can you do under those circumstances? Now the mother wants to relocate. She wants to go overseas. A divorce order says, but the father has guardianship rights over the minor child. What does she do? She cannot notify the father of her intention to go. She would like to approach the court, but how does she notify the father of her intention to approach the court? Or how can the court be convinced that the father knows about this? So this is where we have to now deal with a situation concerning substituted service or edictal citation, depending upon the facts of the matter. If the father is presumed to be overseas, substituted service, not edictal citation, we'll obviously have to now inform the father via various means. If the father is last known to live in South Africa, an advertisement in the local newspaper, maybe if you live in Cape Town, in the government gazette, in various documentation that is publicly available that could potentially notify the father of the intended application that the mother wished to make for sole guardianship rights or for the relocation of a minor child to a different country. What the court needs to know, in no uncertain terms, that the mother tried everything possible to try to inform the father that she intends to relocate to a different country. That's why, and the government gazette would be applicable because that the government gazette is applicable to the entire country. If the father, for example, last known address would have been Johannesburg, she done some searches on him. She got a detective to do some searches on the father, ITC checks, and the last place they can figure out the father stayed, or the last place he made use of credit checks or recreating a cell phone or open a bank account was, for example, Johannesburg, then it makes logical sense for us to presume that that is his last known address where he stays, and to advertise in the local paper in Johannesburg that the mother intends to make an application for the relocation of the minor child. So she'll start the court process, start the documentation, however, ask the court permission, can I inform the father in the specific means? The court will not be unreasonable and say, if the father is not notified, I will not allow you to relocate. It doesn't make logical sense, because must we now be at the mercy of this father who cannot be found and stay in South Africa indefinitely until we find this father, and he can just do whatever he wants. So maybe he's enjoying life, traveling the world, having a good time. This is a fictitious scenario, of course. Or the court look at the matter holistically and say, you know, Mom, I'm looking at your documentation. You have a strong case to relocate. Let's try to find the father. We'll try whatever we can do. We'll do what we can do. If we cannot find the father, too bad. And maybe by advertising in the newspapers and the government, because if the father sees it, but the father decides, you know, I'm not doing anything about it, And obviously, we can presume that the court would not make an order unless the court believes it is in the minor child's best interest to make the specific application. If the father is known to be overseas, let's say the father lives in Germany, and the father has a Facebook account, we have a telephone number, and then you can tell the court or ask the court, court, this is urgent, I need to relocate overseas. Father lives in Germany, I see his Facebook account is busy, this is his account, his sister and his brothers can confirm that, but he does not want to answer the phone calls, he does not want to get involved in this process, he does not want to know me at all. Can we serve the court paper on him via his Facebook account, or via WhatsApp, or via email? And that's where the detailed citation comes in. It's an application we make to the court, asking the court authority to serve the court documentation on him in a different country. So there are various ways and various mechanisms available in our South African legal system to assist people who have challenges in notifying and informing other parties of pending legal matters. I hope that answered your question. On those specific topics, I have a live question on Facebook Live. Let's deal with that. Would the court take the same approach if the father who wants to relocate with the child? Let me just copy that onto the whiteboard. This is question 4, a live question. Let's put this over here. Question 4, live. If you have a question, you're welcome to make use of the Advocate Mohammed Addo Facebook page. And I see this question, also additional question. I was added, pin it under that specific question as well, question 4 as well. And then I have another question 5, and I can maybe deal with all of them at the same time. Okay, this all comes from Advocate Mohammed Addo Facebook page. Okay, so let's make it a question mark. Okay, wonderful. Thank you very much for those questions. So let us deal with question number 4, the live question. Would the court take the same approach if it's the father who wants to relocate with the child? An additional question would have been to that specific questioner. If the mother has a history of alienating the child from the father, would the court allow her to relocate? Okay, so that is basically 2 questions. Yeah, it's the same approach. The court focuses on what is best for the child. It's a difficult one. If the father was never the primary caregiver of the minor child, I'm dealing with the first part, the highlighted section of the question. If the father was never a primary caregiver of the minor child, the mother was always a primary caregiver of the minor child, despite the background information. And the father now wishes to relocate. It will be extremely difficult for him now to convince the court, telling the court, I never looked after these kids primarily in the past. However, I wish to relocate, and I would like to take the mother away from the primary care of the kids away from the primary care of the mother. My apologies for that. And I would like to care for them in a foreign country, in a different country, which they're not used to. If the mother agrees to that, maybe it can work, and most probably it will, because she agrees to it. If the mother objects to it, the father will have an extremely difficult job to convince the court that the minor children will be best cared for by him by swapping the parenting roles. The best thing, which I would say for this specific father to first do, you first have to win the first leg, to convince the court that he intends to live in South Africa, to remain in South Africa, and there win primary care over the minor kids. Put it that way, for lack of a better way of explaining it. So you'll first have to obtain primary care of the minor kids, where the kids will primarily live with him in South Africa. Let that continue, and let the court be convinced therewith. And then thereafter, you can approach the court and say, court, I looked after the kids very well in South Africa. Now I would like to relocate. And the court can now look at a second leg. Would the relocation be in the minor children's best interest? Because if the court deals with the matter from a point of view whereby the father is not the primary caregiver and you would like to relocate, the court will have to deal with 2 scenarios. Number 1, can he primary care for the minor kids? It will be very difficult for him to prove that because he has not done so, and despite the mother maybe being the one that refused him contact. And secondly, would the relocation be in the minor children's best interest? For the mother, her case will be very easy. She can say, I can sit back over here. it will not be in a minor children's best interest because I always looked after them and I can care for them. Therefore, the father should not have primary care. And secondly, how can he have primary care and relocate if the kids are not used to living in his care? So her case will be very easy. So the second part of that question, which I will highlight now, if the mother has a history of alienating the child from the father, would the court allow her to relocate? The end of the day is, if she has a history of alienating the father from the minor children, the court will ultimately still have to make a decision. Number one is it in the children's best interest for the relocation to take place? If the kids are living in South Africa and the schools aren't so good and the mother is not earning enough money and she's struggling, etc., and living overseas would be best for the kids, despite her having alienated the father from the minor children, the court also makes a sense that is a separate issue, because has the mother alienated the father from the minor children? The father should, of course, have taken the matter to court at that specific time, fought for the minor children, and tried to negate the alienation. But if the father done nothing for some time, and now all of a sudden, now that the mother wants to relocate, the father says, I now want to challenge this, and I do not want the mother to go because the mother has alienated me from the minor children. That might not work so well if you consider the possibility of the children having a better life overseas. So those are two separate scenarios that might apply. My advice to the specific person would be, your first option would be fight to have the alienation scratched or like swiped off the table, in the sense of prove to the court that the child is being alienated or the kids are being alienated from the father. Have the court reinstate contact as soon as possible. After that has taken place, then you'll be in a better position to argue your relief which you are seeking ultimately. Okay, that's question number 5. If I did not answer question number 4 too well, the live question, feel free to leave another comment. Question number 5. What happens when the father purposely ignores request for signing documentation? Now, if the father does not want to sign documentation, the court can overrule his right to sign documentation. So what generally happens is we give the father an option. The father should sign the documentation within 24 hours or 7 days, depending upon the urgency of the matter, failing which the sheriff of the High Court would be authorized to sign it. Alternatively, his rights to sign the documentation would be dispensed with. That's what basically what you're asking for. So if people do not want to sign, wonderful, the court will look at the matter. The court will say, under these circumstances, I'm making an order. Father, sign. If you do not want to sign, well, in 7 days' time, your rights to sign is dispensed with. So that's basically how it works. Okay, I have another question over here, and I think it follows. The last question is question number 5, additional comment. Let me copy it quickly. Okay, the question is as follows. Can this be taken to the family court or have to go through the High Court? When it comes to issues concerning consent, I believe for a passport application, the Children's Court does assist you with that. That's not a problem at all for the father to consent to it. But when it comes to issues concerning like relocation, where the minor child will now have to leave the Republic of South Africa, my understanding or my experience are that the Children's Court do not deal with those type of matters. I might be wrong, and remember there are hundreds of Children's Courts in South Africa, but my experience is that the courts refer you to the High Court to deal with those specific issues, especially when it comes to guardianship issues, the appointment of guardianship rights and so on. But when it comes to a passport application, I have had experience with clients of mine have approached the Children's Court, and the Children's Court have granted them the relief for the father to consent for the issue of a passport, failing which his consent is dispensed with. But the Pacific Children's Court referred the client to us, not to us necessarily, but the client had to not get legal representation because they never dealt with the other part, giving the mother sole guardianship rights. And I would believe for relocation, it would obviously have to be more than likely the High Court will have to deal with the matter. Okay, I see the questions are coming in. I have an additional question. Let's make this question number 6 on the Facebook Live. It's 5. And To those of you who have joined us now, you're welcome to pose a question on the Advocate Mohammed Abduroaf Facebook page. The question goes as follows. If the father is financially able to look after the child, would the court still allow the mother to uproot a child and relocate for a job? The issue of finance and caring are two separate issues. A parent can have millions of rands in his or her bank account, but if he cannot care for the minor child, it's possible under those specific situations where a parent pays for everything regarding a minor child, but has no rights of contact and care for the minor child. So having money in the bank account, being able to care for a child, does not actually allow you the right to have contact and to have primary care over a minor child. So if the father is financially able to look after the minor kids, that's a one aspect. But the question is he able to care for the minor kids? Is he theoretically able based upon assumption, or is he historically able based upon him having proven that? And many times the problem comes about because he has never been given that opportunity to prove that he's able to care for the minor child. Or the last time he cared for the minor child could have been many years ago, when the parties separated or in the divorce, whatever the case may be. So it's a dual leg. Now that the mother wants to go overseas and relocate for a better life for the kids, now the father wants to come to the picture and say, no, the kids must stay back here because I can look better after them. But if he can look better after them, why didn't he approach the court long ago, before the issue of relocation was on the table, and prove to the court, then I can look well after them and care for the minor children? So, but ultimately, the court will have to make a decision. If the court looks at an application by the mother to relocate overseas, and there's also a counter application on behalf of the father where he says, no, I would like the minor children to remain in South Africa despite me not having been their primary caregiver in the past, but I am capable of caring for them just as well as a mother can, or better, and their needs will be better looked after remaining in South Africa. That's a good scenario, because let's say, for example, the father can prove that. He can prove that the kids staying with him in South Africa will be better for them than to go overseas. And the court is convinced, obviously the court will rubber stamp that specific scenario. But the court needs to be convinced, number one, he can care for his kids just as well as a mother can care for the kids. The emotional, psychological, physical well-being will be looked after living in South Africa, and the mother is welcome to go overseas on her own. If he can prove that, the court will make such an order. The court should make such an order because it is in the minor child's best interest to remain in South Africa. But if the court looks at the matter holistically, the court sees the mother is the only one that can care for the minor children. She has always cared for the minor children, and there's a better life for the minor children than her overseas. The court will have to make an order that the minor children should relocate with the mother overseas. Okay, I got a rephrase on that question. Let me put that in over here. And then I also have an additional question regarding question number 5. I'll deal with that shortly, and I'll add this into question number 5, dealing with and school applications. But let's deal with the rephrase part first. If the mother's reason for moving is finances, but the father is able to look after the kids financially, why would a court allow her to move and separate her from a loving father? So that depends on the circumstance of the matter. If the parties are having care, if the father is having care to the minor children consistently, he's well involved in the minor children's life, etc., and he's capable of caring for his minor children. Capable. You know, if the kids wake up in the middle of the night, he's available. He's available to take the minor children to school. He's available to attend to their homework, etc. He's able to do that. Then a strong case can be made for the father to argue that the minor children should remain in South Africa and be cared for by him, because there's no necessary a difference in the caring capabilities. Yes, he might have the children every second weekend and midweek contact with the minor children, but he's just as capable of caring for the minor children as a father is. It's a factual thing. It does not mean that I have money in my bank account, I am financially sound, I can care for the minor children. I can help them with their homework, the emotional needs, the psychological needs. They wake up in the middle of the night, they run to the mom. Can the father deal with that? Will it be in the children's best interest for that to happen? Or will it be in the best interest for the minor children to remain with that primary caregiver and move around with him or her? So my guess is as good as your guess. It all depends upon what argument you wish to present and what you can prove to the court. But if the mother is caring for the minor children. That's where I'm going to. She is a minor children's primary caregiver. The issues about her alienating the father, those are important issues, but that is not being seen by the kids. The kids are being cared for well by the mother. Their homework, they're straight A students. When they are ill, the mother knows how to deal with the medical problems they have, knows how to deal with emotional, psychological well-being. She knows how to deal with all of that. But she needs to go overseas to better life and to get a bit more income. The father, on the other hand, does not have those capabilities. He has not cared for the minor children in the past as well as the mother. He's a weekend dad. He sees the kids every second weekend. So whenever he sees the kids, they go to McDonald's or Nando's. They live a good life. They have fun time with the dad. Homework is done. Assignments are done. They have the father's care of contact with the father every school holidays, half the school holidays, fun times. When it comes to the important things, the mother is the one that attends to the schooling, the teachers' meetings, dealing with problems with the minor children should have, attending to the minor children's extramural activities, etc. That is where the mother comes in. So we're not dealing with my fictitious scenario over here. That is where the mother is. She is a true primary caregiver of the minor children. The father is a secondary caregiver. If the argument is that the minor children should remain with a secondary caregiver and the mother is allowed to go overseas, the question is, can the father look after the minor children just as well as the mother? Because he's financially capable of doing so, the minor children will remain in their school, they will remain with the family in South Africa, they do not have to change friends, they also have the same friends, the structure will not be broken down, they will not be going to foreign countries. Those are the positives by remaining in South Africa. But the question is, does the father have the capabilities to care for the minor children? If he does, your case becomes very, very strong. So I hope I answered that specific question. I see more questions coming in. Well done. Welcome. Thank you for that. I will deal with another question number 7 shortly. Let me just deal with this question number 5 with the person added, and school applications as well. School applications, I'll be honest with you, is a conundrum which I have to deal with. I spoke to some family advocates once regarding that issue. The question is, how does a court or an expert make a recommendation or enforce parties to enroll a minor child into a certain school? Because certain schools have certain, financial implications. Now, the court will obviously make an order regarding that. So a problem which might arise is that you believe a child should go into a certain school, the other parent believes no. But at the same time, in order for you to enroll that minor child to that specific school, you would obviously require an assessment to be done, an application process to take place, and both parents' signatures will have to take place at the end of the day. If the other parent does not want to consent to it, of course, you can approach the court for that. You can approach a children's court, but it's difficult for me to say, yes, the children's court will definitely assist you regarding a school. They might make a the experts, the social workers might come on board, and they might make recommendations as to what type of school the child should go to. By the end of the day, I doubt the court would be able to force the parent, saying that the child must go into that specific school and you must specifically agree to that, because there are financial implications involved. But at the same time, it is possible for the court to make such a decision. If the court has all the information before it, the affordability of the school, and so on. Because one parent says, I cannot afford for the child to go to that school, but other parents say, no, that's not my problem. You should sell your house, you should sell your car. Would the court, get involved in that specific situation? But ultimately, a court can upon all the information submitted to it. I hope that answered that specific question. Okay, I have another question over here. Let me deal with that. We'll have to end this webinar on the dot at 12 o'clock, but until then, I will deal with whatever I can. Okay. We have a question number 7 over here. It. Question mark. Okay. Question number 7. How can an individual approach the High Court without legal representation for a child passport should the other parent refuse? Yeah, you can approach yourself. You do not need to make use of legal representation. So you make a normal notice of motion with a founding affidavit, serve it up on the other side, serve it up on the Office of the Family Advocate, set the matter down, let the other party obviously file the opposing papers if they have any papers. So that's obviously the technicalities thereof, but it is possible. I don't think this webinar can deal with that. How to unpack the application, it is possible. There should be some information on the Our Lawyer website regarding court applications, urgent court applications. I think there is some data with it, some documentation that you can download as well. So that should assist you, but it's possible to make an application to the High Court without legal representation in a passport application matter. Okay, let me just deal with these matters properly. I hope I answered that specific question. I'm trying to deal with these matters one by one so I do not miss out anything. Okay, here we go. What if the father is awarded interim primary care? Will the same apply? I think if you awarded interim primary care and you wish to relocate, it becomes a bit more complicated. I think the court will stipulate that let us first resolve the issue concerning final primary care first. If the court concludes that he will be the final primary caregiver of the minor children, then we can deal with the second leg as to whether or not relocation will make sense or not. So I'll answer that question for you, and thank you for it. Question 9. Okay. Do the courts still assume that mothers are automatically or by default better parents, a maternal preference doctrine, which is violation of the rights of equality? I never experienced that for many years, so I argue against preferences. I have clients who ask me, does the courts assume that fathers are better caregivers? Is there a presumption in that specific regard, or that fathers have rights to the minor children more than the mother? So I think that's an old concept. You might be unlucky to have a magistrate because of your matter finds more in favor of the mom, and you might be unlucky as a mother to have a magistrate finding more in favor of the father. But I think it depends upon the facts of the matter. But the law doesn't say that. The law looks at parents individually, not based upon their gender. Of course, if a child is born now, it's best for the child to be with a mother. I can't argue against that. No matter how a father would want to argue it, if all else is equal. However, as the child gets older, it's possible to argue that the child might be better with a dad based upon the facts and circumstances. Question number 10. Can you only approach the High Court for a child passport, or may an individual person approach a children's court? I think I answered earlier on, you may approach a children's court based upon my experience, but also depends upon your specific magistrate's court. Some of them might decide, no, go to the High Court. Okay, I hope I answered that. I got another question here. I will only be able to take questions until about 11, because I have to have another meeting on. And oops, let me take that out of there. It is not based on a specific school. It is about just signing school papers. The father refuses to sign anything when it comes to the child and their future or development. The father currently doesn't even pay towards schooling, but won't sign any documents out of spite. So I think under those circumstances, you're dealing with an issue concerning guardianship rights. Guardianship rights deals with those type of issues regarding the issue concerning enrollment of schools, medical consent, relocation issues, etc. If you are having problems with the father regarding educational guardianship right issues, it may be a good idea for you to approach the High Court and get an order that you are the sole guardian, that you have sole guardianship rights when it comes to issues regarding schooling of the minor child. I think that might be a good idea for you to consider and look into that. Then you wouldn't have any problems regarding education in the future. Okay, I hope I answered that specific question. And there's a challenge you have just before the webinar comes to an end. The questions comes in, but are always welcome to pose it. Let's go. The last question, or the second last question. If the father has left RSA due to being a foreign national and has not seen the children in 7 years, how can a mother apply for a passport of the children, not for relocation purpose, but for a general travel? Yes, she can still apply to the court. I think if you watch a previous part of this video, at the start of that video, I dealt with a scenario where you cannot find the father. I think it's question 3 of the specific questions. If you cannot find the father, you can still approach a court, and the court can make an order that you can still relocate even if you cannot find the father. It is possible with legal assistance. And the last question, I think you could have heard the noon gun here in Cape Town. And this will be the last question for today. I need to be somewhere else shortly. Okay, there it is. Does the primary caregiver have the final say in which school the child goes to if the other parent, not being the primary caregiver, objects? No, no. Those are important decisions regarding a minor child. Therefore, you have to make a joint decision. You should either go to a mediator or for a professional person to assist you. If the primary caregiver by default had to have the final say, then there would not have been any need for the consent of the other parent. So you need the other parent's consent. It also depends upon the school. I mean, some schools wouldn't mind, but legally, you require both guardians' consent for the minor child to be enrolled to a certain school, because it is it's a important fundamental decision regarding a minor child's life. A child either goes to primary school and goes to a high school. Very important. So both parents' consent should be, or input should be, given when it comes to the appointment of a school for a minor child. Some parents just go with the flow. You decide, mom decide, or dad decides. But if there's a dispute, the court can get involved, and the court won't make a decision saying, okay, the dad in the first place, he had the final say, or the mom had the final say. Both parents, but the court can get involved and make a decision. Okay, that was the last question. Thank you very much. My apologies for having to rush off. Yes, we're online now, but for 40 minutes, and that was the target time. Thank you for joining, and I hope to see you online tomorrow. I will be online again tomorrow. And if you have any questions, please type it out now and copy and paste. And copy and paste it tomorrow. Have a lovely day. Thank you very much. Good morning. Thank you for joining us on this live webinar dealing with issues concerning child custody, child maintenance, and divorce. This is the third one. We started the first one on Monday. We had one yesterday and another today. If you would like to watch the others, we dealt quite extensively on the issue regarding child maintenance and child custody. Please go on the Facebook pages and have a look at the previous videos, and you'll be able to obtain some relevant information to assist you. As stated, this topic will be on the issue of child custody, child maintenance, and divorce. We are streaming live on Facebook pages. The only page that I would be able to properly see any questions that you pose would be the Advocate Mohammed Abduroaf Facebook page. Therefore, if you are not on that page, please visit www.abduroaf.co.za/live, and that should take you to the relevant Facebook page link, whereby you can pose questions on the issue concerning child custody, child maintenance, and divorce. Feel free to do so, and hopefully we'll be able to assist you in answering any legal questions you might have on this specific topic. There were many questions posed yesterday. Unfortunately, due to time constraints, these videos takes about 25 minutes to half an hour. Therefore, if you have a question, please pose it as soon as possible. So let us begin. We discussed quite in depth, as I mentioned earlier on, the issue regarding child maintenance during the national lockdown. I'll quickly recap that one more time. If a parent cannot afford to pay all the child maintenance as ordered to do so, please approach the maintenance court as soon as possible to have the order relooked at. Basically, make an application for a variation of the maintenance order. The court will look at all the circumstances of the matter, and then the court should make a decision. If there is no maintenance order in place, please still continue paying child maintenance. If you lost your job, sell property, sell assets, whatever you have, and use that in support of the minor child. You have no legal obligation to maintain another person, the other parent of the child, unless a court ordered you to do so. Therefore, both parents have to be reasonable, and they have to, fulfill the obligation of the principle that both parents have to pay adequate child maintenance and not excessive child maintenance, for lack of a better way of phrasing it. Therefore, if you have any questions, please feel free to pose it. We are on Facebook Live. I am taking questions, and I'll be able to answer it for you. And hopefully from there on, we can go forward. Let's touch today on the issue concerning divorce. The starting point would basically be what happens before you get married. And that would be the issue regarding the matrimonial property regime. We all know, I presume we all know, that the default matrimonial property regime in South Africa is that of in-community of property. Basically, what that means is that whatever assets, liabilities, debt you have before the marriage of both spouses gets placed into one pot, and that becomes the joint estate. If you marry someone who owes a third party, let's say 10,000 Rand, and you have in your bank account at the date of marriage 10,000 Rand, that 10,000 Rand may be used to pay that specific spouse's debt of that 10,000 Rand. Therefore, if you are concerned about marrying someone, you're concerned about the financial impact it may have should you marry this specific person in community of property, because this person might have a lot of debt, or you may have a lot of debt, and so on. Then you may want to consider the other matrimonial property regimes, and I'll mention them in a moment. If you are married in community of property, it's simple. It's one estate. There's no longer two estates. At death or divorce, that specific estate will have to be divided. It's impossible to say that if there's two homes in the joint estate at death or divorce, one home belongs to the husband and one home belongs to the wife. That's not how it works. You basically own one half of an undivided share of the joint estate. Basically, if you can't come to an agreement regarding what should happen to both those homes, it should be sold, and the proceeds must be divided equally after all the debts have been paid and so on. That's the issue concerning whether or not you get married in community of property. If you want to protect your assets, or if you are concerned that you may, get into some financial trouble sometime into the marriage, and you are worried that it might affect the other spouse or it might affect you, then you may want to consider getting married out of community of property. Basically, what that means is there is now two estates. You will retain your estate, and the other party will retain his or her estate as separate estates. Whatever debt the specific spouse brought into the marriage will belong to that spouse. So a creditor, for example, a clothing store, will proceed against that specific spouse for whatever debt or whatever account is outstanding or in arrears. That applies to the issue concerning married out of community property. But however, being married out of community property comes with two possible scenarios. The first is out of community property with the inclusion of the accrual regime, or out of community of property with the exclusion of the accrual regime. The accrual regime basically means that during your marriage, if you are married out of community of property, there remains two estates. You own your property, you own your debt, the wife owns her property and a debt and so on. But at death or divorce, then a calculation gets made. Whatever growth there was in the specific spouse's estate, the other spouse will benefit from half that, the growth, the accrual thereof. If you, at the start of the marriage, the husband's estate was 0 and the wife's estate was 0, if the estates are negative, it's still referred to as 0. And at the divorce or at death, the husband's estate is worth 10,000 Rand and the wife's estate is worth 20,000 Rand. If the accrual regime applies, it means that the husband will get half the difference, meaning he will get 5,000 Rand from the wife's estate. So if you add it to 10 plus 20 is 30, divided by 2 will be 15. So each party will leave with 15,000 Rand. You're only entitled to money, so you can't say, I would like to get my spouse's car or a house and so on. You're entitled to the value, the financial value thereof. Obviously, there are ways of calculating the accrual. Certain assets are not included, CPI gets applied and so on. But that's a basic principle. During the marriage, there is two separate estates. If you are married out of community of property with accrual regime, at death or divorce, whoever made more money or whoever estate has grown during the marriage, the person whose estate has grown less will acquire half the difference. As I said, now there are certain calculations, but if you are considering getting married out of community property with a accrual system, you need to look at the Matrimonial Property Act, and you need to understand what the implications thereof are of, in the sense of what applies to inheritance, donations between spouses, and so on. What if there was a motor vehicle accident and you obtain some money? Does that also form part of the accrual? What if I sell my house that formed part of that was mentioned in the Antenuptial Contract, and I bought another asset with that specific home? What happens with that home, and so on? So those are the issues which you have to now understand and discuss and come to an agreement before your marriage. Then there's a third matrimonial property regime, the one of being married out of community property without the accrual system. That's, in simple terms, a simple what's yours is yours, what's mine is mine, at the start of the marriage and at the end of the marriage. So if that specific spouse divorces, then he leaves with whatever he has and she leaves with whatever she has. Obviously, there can be the issue concerning personal maintenance. If the husband wants to claim personal maintenance from the wife, or the wife would like to claim personal maintenance from the husband. So those specific issues can be looked at and dealt with at a specific time. However, out of community property, in my view, if you are a business person and you are concerned about being, getting into financial trouble and you do not want to burden your other spouse, then I would advise getting married out of contempt of property is the best way forward. Now let's move on. So discuss that with a lawyer and come to an agreement regarding what is the best matrimonial property regime for you and your spouse. Now that the parties are married, so today's topic is, let's get back to it, child custody, child maintenance, and divorce. And I had to put down the prelude regarding the issue concerning divorce. If you do not understand what matrimonial property regime we have entered into, you won't understand how the divorce takes place. So in order for someone to get divorced, the marriage has to have broken down. No court of law will divorce a couple who are happily married. It won't happen. They basically say that the marriage has to be irretrievably broken down, the marriage cannot be saved, and so on. Basically, the normal scenario would be there's no love and affection between the parties. The parties have been living separate for the last many months. Many times it happens that they've met someone else and they no longer want to be together. There's no love and affection and the marriage has broken down. If that is the case, then the court will obviously be able to divorce you. Before I go on, please, if you have any questions, feel free to post it. I'll try my best to answer it. We are dealing with a topic concerning child custody, child maintenance, and divorce. If you have any queries and so on, we would be happy to assist you via this webinar and advise you accordingly. Moving on, regarding the issue of divorce, if there are minor children involved, the matter becomes a bit complicated because the parties might want to argue and debate or litigate on the issue who gets custody over the child or the children. A court will not grant a decree or divorce unless a court is convinced that the minor children's best interests are being upheld. With minor children, there comes the issue concerning child maintenance, obviously. So if the father has custody over the kids are living with the father, then the mother would have to pay the father child maintenance, depending upon the financial circumstances. If the mother is working, depending on how much money the father costs and how much the kids cost, and so on. That would be the general scenario. Then there's the issue concerning visitation, which I mentioned earlier on regarding the kids. The issue concerning if there are any property, the matrimonial property regime. If there are married income in their property, the joint estate must be divided into two and split between the parties. If there are pension funds, those pension funds must be endorsed and so on. If the parties are married with a accrual regime, those calculations must take place. And the list goes on. Getting divorced is not always that simple because we need to look at those specific issues. The children, custody, child maintenance, visitation, guardianship issues, and so on. Propriety issues regarding the accrual regime. It should be simple, but it can be complicated because you have to now work it out and not work it out necessarily at the time of divorce, but it needs to be discussed. People have to disclose information. You can't work out the accrual calculations if people don't, come to the table and put the financials on the table. So if the husband or the wife has some money stashed away overseas, that forms part of the accrual. It's a calculation that needs to be, worked out. So the same regarding pension funds. If a spouse has a pension fund during the marriage, income into property, of course, the spouses may not have, disclosed that information. So that information has to be disclosed. Therefore, if you want to have a simple divorce in the future, I would say the most simplistic divorce would be if there are no minor children involved and the parties are married out of community property without the accrual regime. Then automatically, the only issue that could possibly come to fore would be the issue regarding alimony, personal maintenance, but most of the time it's not an issue and the parties can just move on with their lives and continue after the divorce. Now that the marriage has irretrievably broken down, the parties know that they want to go on with their lives. The stumbling blocks, as I mentioned earlier on, would not necessarily be the matrimonial property regime, because that's simple, that's worked out already. We know what must happen. The stumbling block would generally be that of the minor children, child custody issues and child maintenance issues. Sometimes parents believe that they have to fight for the kids, and the father might say, okay, during the marriage, although the last 3 or 4 years, the kids are quite old. They must probably 10, 11, or 12 years old. He was the one that worked most of the time from home. He's the one that cared for the kids, and he believes that the mother should now leave the home because the house is on his name. They're married out of communal property without the cruel regime, and that the kids should stay with him because the house is closer to the school and it will be best for the kids. And he believes he can care for the kids. Now, those are things that must be discussed, and both parties must come to the table and work something out. You do not want the judge to be the person to make that specific decision for you. I would not advise that to be the case. So those things need to be unpacked and discussed and worked through. What happens to the kids? What happens on school holidays? What happens during the kids' birthdays? What happens on Father's Day and Mother's Day, or the parents' birthdays, the children's birthdays, and so on? It's easy to say the marriage has broken down irretrievably. Yes, those things we can see. The parties do not want to be married to each other. But what happens beyond that? Now the court says he grants you, or the judge grants a decree of divorce. What happens then? These are issues that must be discussed, worked out, unpacked, and dealt with properly. I do not believe that template agreement should be entered into. For example, the clause where it stipulates that the plaintiff will have custody and the defendant will have a reasonable contact. What does that mean? What's reasonable under these circumstances? That this brings up a whole floodgate of debate afterwards, because one lawyer will have interpretation of reasonable. His reasonable might be every second weekend, half the school holidays, and so on. But it depends on the age of the child. Where the other lawyer might believe reasonable could mean, half the school holidays, yes, but midweek contact as well. Or one parent can collect the child and the other parent should drop the child. So that leaves a lot of issues, a floodgate for litigation in the future if the parties do not come to an agreement regarding that. So sit down with the other party. Yes, the marriage has broken down. Let's work it out from the first of the month to the end of the month, from the first month of the year to the last month of the year, and from primary school, from preschool to primary school to high school and to university if the kids are still of age. Things have to be looked at and it needs to be discussed. And if it cannot be discussed, it cannot be resolved, then unfortunately, because it cannot be resolved, because the parties cannot agree upon who should have custody over these kids, with who the kids should reside with during the day, and so on. The parties can't come to that agreement. Because of that, the matter will have to go to court, and the court will have to litigate on the specific issue. So I advise everybody, those people who are planning on getting divorced, nothing wrong with that, that's how life is. Please sit down with the other party. Do not let the divorce go ahead being, as I say now, opposed, being litigated upon. 2 or 3 years to finalize, could be longer depending upon the court, the facts of the matter, and the parties, and so on. Thousands of rands get spent on legal fees, and at the end of the day, you would have gotten exactly what you wanted, what you would have entitled to get, but the child is the one that actually loses out in the long run. Thank you very much for watching this video. There'll be more videos in the future. Please follow our pages. It's very useful to do that, and we will remind you of the next one. Thank you very much. Have a lovely day.